insert some of this data, Judge, that I tailored for the court.
But the states is the standard instruction, correct?
Mine's a standard instruction.
Okay, so let's look at the states, and if there's something you would like to add, then please raise that as we get to the appropriate portion of the instruction. So the states, paragraph number 1, any issues?
I think that's the standard there, Judge.
All right. So we're moving on to Laurie Shaver was justified in using or threatening to use deadly force if she reasonably believed that such force or threat, that those 3 paragraphs.
When I put Laurie Shaver, I put in it, Laurie Shaver was oh wait a second. Yeah, that Laurie Shaver does not have the burden of proving. What's that?
That's in there. That was the first paragraph that we already addressed.
No, that's
Yeah.
the one above it.
Yes, well, that is the first paragraph in the document. Laurie Shaver does not have the burden of proving.
Laurie Shaver. You see, Judge, well, the states here, right here, it says, if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another. And it says the imminent commission of an applicable forcible felony against her or another. But it doesn't define at that stage what the applicable forcible felony was against her or another. So that's where I think you got to insert the required language or what she reasonably believed was the applicable forcible felony for the jury. That needs to be defined.
All right.
I agree, that's why it's set up this way to be addressed. So
It is printed in bold, so.
Felonies, are you asking for?
Look at my jury instruction. I think I defined it in there.
All right, you listed attempted murder or aggravated battery, correct?
You may have to go down further, Judge, where it says threats of a forcible felony. On the following page.
Yes, I'm there, page
Yes.
2.
Okay, and that's where I think there's a definition that's provided in it or throughout. And the applicable forcible felony was an attempt to murder or create great bodily harm. And those elements, I think, are specified or should be specified.
So you're asking for the imminent commission of attempted murder.
You listed aggravated battery.
Aggravated battery.
Correct.
Okay.
And those elements be asserted within the self-defense instruction.
There's a place for it.
Okay, that's what the evidence was.
But the previous paragraph of defining every forcible felony, I don't see how that's not the standard. I don't see how that's necessary. We're not dealing with carjacking, aircraft piracy.
No. That's what I just said, an attempted murder or an aggravated battery. And then give those those elements to the defense. That's it.
All right. Now the next page, in deciding whether Laurie Shaver was justified in the use or threatened use of deadly force, you must consider the circumstances by which, now that portion, that page.
Well, 1 second, Judge. I think you skipped if Laurie Shaver was not committing any crime.
Yes, is that acceptable? That's the middle paragraph of the three.
Okay. Laurie Shaver was not committing any crime other than the alleged murder. Go back.
Okay,
That's correct.
okay,
Laurie Shaver was not committing any crime.
okay. Laurie Shaver was not committing any crime. Yeah, that's standard verbiage.
And the next one regarding the dwelling.
Your Honor, we have to add in the attempted murder or aggravated battery in the bolded bracket area based on the defense's request.
Correct.
Yes, sir.
Yeah, and on that page, we just need to put in, I think where it says defendant, if you want to put in the defendant's name, throughout here and tailor it, take out the himself, herself.
What was that? I left it this way because I initially didn't think that it was relevant to this case, and we're looking at that right now.
You follow me, Judge?
Yes, sir. I see where we're at. And are you objecting to that portion being in?
It just needs to be, the use of deadly force is justifiable if Laurie Shaver reasonably believed that force was necessary to prevent imminent death or great bodily harm to / herself
So we should just.
or Laurie Shaver.
Yeah. Judge, we will make this track with the language and the rest, all the brackets.
Okay.
All right, thank you.
Great, great.
And when it talks about the applicable felonies, we will use the same attempted murder aggravated battery that has been requested.
Good.
All right.
That brings us in deciding whether Laurie Shaver was justified.
Okay.
Okay. Any issues with that page?
Let's see. Yeah, that's fine, Judge.
Okay, the entire page is acceptable?
Yes, sir.
All right. Okay, and the next page. If you find that Laurie Shaver, who because of threats or prior difficulties with Michael Shaver had reasonable grounds to believe, any issues there?
No, sir.
All right. Okay, then we're on to 3.6G, justifiable use or threatened use of non-deadly force. Okay, let's discuss page 1.
Well, Your Honor, the state is objecting to that instruction in its entirety.
We talked about a proposed instruction I've drafted?
Yes, your
Okay.
proposed instruction for justifiable use of non-deadly force.
Okay. I thought it says a mandatory lesser under the giving of the other statute. Okay.
Your Honor, I'm citing to Hosendel, Hosnedl, State
Thank you.
128 Southern 3rd, 400. Your Honor, this case and others cited within it stand for the proposition that the discharge of a firearm is deadly force as a matter of law, and the discharge of a firearm is the only scenario in which the court should basically only give the justifiable use of deadly force and not extend the justifiable use of non-deadly force. I would direct the court's attention to page 4 the end of it starts on page 3, goes on to page 4, which is the head notes 3, 4, and 5. On page 4, it goes on to say the discharge of a firearm has been held to be the use of deadly force as a matter of law. In Miller, the court found that firing a firearm in the air, even as a warning shot, constituted as a matter of law the use of deadly force by the defendant. Thus, the trial court did not commit reversible error by not giving the instruction of the use of non-deadly force.
All right, Mr. Wiggs.
Yes, I would say this. We have a separate requirement in the jury instructions proposed by the state that they separately and independently have to find that there was a firearm used. Okay? If there's not a separate finding that a firearm was used, then that becomes a discretionary issue for the jury, and they could conclude that there was non-deadly force. So I think it's appropriate. I think it's mandated right in the instructions themselves.
The instruction for the justifiable use of deadly force specifically cites to this Hosendall case and says that in those situations only the justifiable use of deadly force instruction should be given.
All right, the state's objection is sustained. 3.6G, justifiable use of non-deadly force, will not be given to the jury. Only 3.6F, justifiable use of deadly force. Is there anything further? We have plea of not guilty, reasonable doubt, and burden of proof. Is that acceptable?
Your Honor, can you give us one moment to go back to deadly force?
Yes, sir.
About 4 paragraphs from the bottom, if you find that Michael Shaver had a reputation of being violent and dangerous person, there's been no reputation evidence, so that paragraph should be stricken.
Good, Judge. We've heard actual physical...
The next 2.
No, we've heard testimony. We've seen exhibits offered into trial about consequences and acts of physical violence. So it becomes very, very significant. It's even spoken about by the daughter and the mother that there were acts of physical violence justifying the claim of belief that there was an attempted murder, and there was a monthly ongoing act of physical violence that was spoken of by the daughter. It's in the standard jury instructions that those specific events be included when warranted. And the statute and the law requires there's got to be some confirmation, some circumstantial confirmation of violence. We introduced the photographs to confirm there have been past acts of violence. There was testimony about the injunctions and the requirement that he leave the residence. So again, the acts of aggravated battery and domestic violence were testified to, and that those specific instructions should be included within the jury instructions and not excluded. They're standard instructions.
Yes, sir.
Evidence that he's referring to that he wants to reference as to why that this is permissible use of deadly force is covered in the previous paragraph. If you find at the time of the alleged murder in the second degree, Laurie Shaver knew that Michael Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver reasonably believed it was necessary for her to use or threaten to use deadly force. The 2 paragraphs that I am asking to be stricken specifically go to whether or not reputation evidence was presented. First, reputation of being a violent, dangerous person, and whether or not that was known. And then 2, reputation of being a violent, dangerous person. You may consider that as far as whether or not he was the initial aggressor. There's been no reputation evidence. There has been acts of other violence, which is covered in the instructions already. I'm just asking for the redaction of the language that deals with evidence that has not been presented.
Judge, in there's case law, and it's in Earhart sitting on my desk, and it talks about that the family is such a narrow community, you can never establish reputation to offer that specific conduct. So we do have evidence that there were past acts of violence. I'll leave it to the court as to whether you want to just delete the paragraph or you want to put in, again, reference to past acts of violence as demonstrated through witness testimony.
You're saying leaving in the second paragraph stating...
I believe, yeah.
All right, so you have no objection to the reputation being removed?
No, I just think if you want to tailor that, it should have to be tailored to represent that you've heard testimony that there were past acts of a physical nature of violence. Such acts may be considered by you in determining who was the initial aggressor. I think it could be tailored that way because, as I stated, Earhart declares that you can't establish reputation within a home environment.
But he's conceding that there's no reputation evidence, so these two reputation paragraphs should be taken out.
No, I'm saying they should be tailored now.
And once again, the paragraph that precedes the ones we are talking about, the two paragraphs that we precede that we're talking about, if you find that Laurie Shaver, because of threats or prior difficulties with Michael Shaver, had reasonable grounds to believe that she was in danger. And then two, if you find at the time of the alleged murder in the second degree, Laurie Shaver knew that Michael Shaver had committed an act of violence, both of those cover what he wants. There's the next two deal with a specific presentation of evidence that hasn't been presented, and that's why they should be redacted.
All right, state's request is granted. The two paragraphs relating to reputation evidence will be removed.
And Your Honor, the last thing I just want to address on the record before we move on, the way the standard instruction is drafted and presented basically is very much focused on a self-defense claim as opposed to defense of others. And the state realizes that this is what they really are going for is whether or not Isabel Shaver was aware of these things and acting in defense of others. So I believe that those areas
They need to be included.
where I would say in that if you find that Laurie Shaver, who because of threats or prior difficulties, I think that we can put for Isabel Shaver in acting in defense of others. And hold on 1 second.
Any objection?
No, I made notes on that as well, and I didn't know what the specific instruction was. I thought the state knew that Isabel was going to say this, and I thought actually they put it in their primary instructions.
So please modify the instruction accordingly.
Yeah, just put in the defense of
I
others.
was kind of waiting to hear how the defense would want to handle that, sir, but that's why I brought it up.
Yes, sir. So there's no objection.
And we will work on that. We will make sure we print out prior to any final instructions. Just, we'll address that again to make sure there's no further changes that need to be made later today.
Yes, sir. All right, 3.7, any objections?
Judge, one moment, please.
Yes, sir.
Since we're dealing with the substantive crimes and instructions up to this point, let's say, we had requested instructions on consanguinity.
He wants to go back to the
Accessory?
accessory after the fact.
All right, I have that. Consanguinity as a defense. I've read over it. And the state's position?
He's referring to a statute that has been modified and changed. The statute, the cases that he cites refer to a statute that was modified in 2006. The statute as currently written, I have copies for. Your Honor, may I approach?
Yes, sir.
That is 777.03.
Thank you.
Paragraph B, any person who maintains or assists the principal before the fact or gives the offender any other aid knowing that the offender had committed the offense of child abuse, neglect of a child, aggravated child abuse, aggravated manslaughter. Apologize. Paragraph C, any person who maintains or assists the principal Any person who maintains or assists the principal or an accessory before the fact or gives the offender any other aid knowing that the offense had been committed a crime, and such crime was a capital life, first degree or second degree felony, or had been accessory thereto before the fact with the intent that the offender avoids or escapes detection, arrest, trial, or punishment is an accessory after the fact. The discussion of people being in relation, which is what Mr. Wiggs is referring to, is in paragraph A, which deals with someone that is a accessory before the fact. So the language that he is requesting is not appropriate, and that's why the standard instruction does not include any of that.
Any person not standing in the relation of husband or wife, parent or child, grandparent, brother or sister by consanguinity, who maintains and assists before the fact, okay, or gives the offender any aid, knowing that the offender had, which is after the fact, committed a crime, and such crime was third degree. Now that's third degree.
Right.
Okay, or had been an accessory there too before the fact with the intent, okay? And the offender who maintains, I wish I could read this almost.
Your Honor, you can't be an accessory after the fact if you are a relative to a third degree felony.
No, that's fair. Let me read
All right,
it.
please take turns. Mr. Camuccio, anything further? Okay.
No, I think it's still applicable based on the law that I cited to the court, and I don't see where this case has been overturned, Judge, which was Brown v. State, and it states that Marshall had been charged with a second-degree murder, and Brown was charged with being an accessory after the fact. He first asserts to one guy that there was a relationship of consanguinity as a defense, and that was his defense. The court said, well, you're too remote in the relationship to assert that to a second-degree murder. I don't see where clearly what Mr. Camuccio at the last minute, having produced these weeks and weeks ago, is providing that says that this has otherwise been revoked or overruled.
What your
Honor, this case provide something with mice type to try to read off of. I've read the statute update. I don't see, this is a 2006 version. I've read the latest version of the statute, and I don't see where it changed, as Mr. Camuccio is suggesting here.
Your Honor, may I approach?
Yes, sir.
Here's the copy of the statute that was in effect before 2006, which is that Mr. Wiggs cites was the statute at the time. So in 2006, when the Florida legislature changed the statute, the standard jury instructions were changed to comport with the statute, and that's how the cases Brown and Bowen. Bowen was from 2001. Brown was from 1996. Have been abrogated.
I don't believe so, Judge. I'm looking at the current statute, and I don't think that's the position. I think it's still in effect. It's a still viable defense, and we request the instruction.
All right, the request is denied. 3.7, plea of not guilty. Acceptable?
If this is just a standard, Judge?
Yes, sir. Okay. 3.9, weighing the evidence. We have to decide yet as to what or if all or any of 6, 7, 8, 9, and 10 will be given.
So this is, let's see where you're looking at.
3.9.
Mine goes from page 3.7 to the self-defense. Okay. Well, 3.9. These are the standard.
Yes, sir, except for 6 through 10.
Pretend that it wasn't said.
Do the parties want 6?
we had testimony from Adam Narvaez about the reputation for truthfulness as to Laurie, Isabel, and Travis. I request that it be included.
So, Your Honor, I don't think we have any evidence of 6.
Correct.
I don't think we have any evidence of 7. We do have.
Judge, I'd ask that 6 remain in, and I'll tell you why. We did hear from Jeremy Townsend. He's represented by counsel. He has an arguable and viable interest in the case. There may be an inference that he has negotiated some kind of obligation or with the state. He's under compelled testimony of the subpoena, so I'd ask that that remain in.
So it reads, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
I think that he could be charged, so there is an interest, so there could be a preferred treatment. That should remain in.
The state's response?
Your Honor, we can leave it in, but there has been absolutely no evidence of any sort of deal. And his arguments that this can be inferred when he knows that I have a Brady obligation to turn over some sort of deal on that, I think would be an improper argument and completely improper.
I'll tell you what, I worked with the state, I worked with Brad King, I worked with Rick Ridgway, and those gentlemen would infer a preferred treatment with counsel and not put it in writing, and it would be silently implied. So to just say, I don't have anything in writing, there still can be an innuendo that somebody's receiving fair treatment. And to just say, I would do it, and I would turn it over, I'm sure if you had it in writing.
I'm quite frankly offended by the attacks on the character of former State Attorney Brad King and former Chief Assistant State Attorney Rick Ridgway at this point. But what really matters is the fact that I do have a Brady obligation. I would have to turn that over. There is no agreement. There is no preferred treatment. And to just make stuff up and infer it to the jury is improper argument.
And I agree, and I work with those same individuals, Mr. Wiggs.
I've worked
Yes.
life cases with them, and that's the way they dealt with me.
And the state has a Brady obligation.
Yeah.
And so if there was any type of agreement, you would have knowledge of that. So 6 will be stricken. Okay, number 7.
I don't think there's been any evidence of any pressure or threat against a witness that affected the truth of the witness's testimony.
Well, how are you going to find that out? How do you know? I mean, the jury, that's a factual determination for a jury.
Well, what evidence has there been, Mr. Wiggs?
I think they can imply something. I think they may infer from their common sense what they heard that there may be.
I've heard no testimony as a state.
No, sir.
Okay, 7 will be stricken. Number 8. Did the witness at some other time make a statement that is inconsistent with the testimony he gave in court?
Yes. There's evidence of that.
Okay, so 8 will remain. 9. Has the witness been convicted of a felony, misdemeanor involving dishonesty, false statement? Yes. So Mr. Filmer testified to 3 felony convictions. 10. Does the witness have a general reputation for dishonesty or truthfulness?
Yes, that remains.
Your Honor, actually what was asked of Mr. Narvaez is, do you know of their reputation? He said yes. He actually never gave a response as to what it was. But if the defense wants that one in there, that's fine.
All right, 10 will remain. So 8, 9, and 10 will remain. 6 and 7 are stricken. Okay, the defendant has testified, so the last 3 paragraphs are applicable.
Yes, sir.
3.9A will be removed, defendant not testifying. 3.9B will remain, defendant statements. 3.10, rules for deliberation appear to be standard. Is there anything further on that?
No, we move on. Okay, 3.9. Go ahead, 3.9B.
Yes, sir. 3.9B will remain. Any modifications?
Yes, sir. In the state's packet after 3.9B is when I included the closing arguments section, because that in the past has been when the cases I've tried have broken up the two sets of instructions before and after closing arguments.
Yes, sir, and I will read the initial instructions prior to closing argument and the remainder after. So I have the closing argument instruction, both at standard. Okay, 3.10, rules for deliberation.
These are just standard, Judge, all the way through, correct?
Yes.
Yeah.
All right. 3.11, cautionary instruction.
Yeah, that's standard.
3.12, verdict.
Correct, that's standard.
Okay. 3.12A, single defendant, multiple counts or informations. Okay.
Wait a second, wait a second. Submitting a case?
Yes, sir. 3.13, submitting case to jury.
Yeah, that's fine, Judge.
And we have the verdict forms. Does everyone have a copy of the proposed verdict form?
One other proposed instruction I'd given, Judge,
Yes, sir.
was the duty to report. I had submitted a proposed instruction on that there was no duty to report a crime just because you had observed a crime. And I attached the authority on that. I think the law is clearly still the same on that issue today.
All right, state's response.
Yes, Your Honor. Let me get that in my... All right. As far as the law that relates to special jury instructions, the defendant must prove, 1, that the special instruction was supported by the evidence, 2, the standard instructions did not adequately cover the theory of defense, 3, the special instruction was a correct statement of the law. That is Wheeler v. State 4 Southern 3rd 599. The court does have wide discretion in deciding whether or not to give or withhold a special instruction. I will say that we have found no case dealing with any sort of special instruction to say that it's not a crime. No one is saying that she is guilty solely by failing to report of the crime, so there's no need to instruct the jury as such. It also creates confusion because we are obviously going to argue that the fact that she doesn't report anything when this is a self-defense claim is a reason to question the veracity and credibility of that statement, and also that we're dealing with consciousness of guilt for the murder itself. So, and there's also the fact that she not only does not report the crime, but lies to law enforcement about the fact that she witnessed this crime, which is part of the accessory after the fact charge. So giving this instruction would be misleading and confusing, and based on the fact that they need to establish that it is necessary and that it's not misleading and confusing, that it should be stricken.
Judge, she's not charged here with lying to law enforcement. That's not the charge. She's not charged with bank fraud. She's not charged with anything other than the charge of murder and accessory. The law still directs that if there's any reasonable evidence to support the proposition of the defense, the court is to grant the proposed instruction. And to do otherwise is an abuse of the discretion of the court. There is, again, the state is thinking that they're going to that the jury's supposed to render a verdict because somebody went on Michael Shaver's account or she made a misstatement to law enforcement. That's not the law. That's not found with any of the instructions that we just went through. So any evidence, if she thought that the body had been removed somewhere else, which we've heard that there was evidence that she believed that the body was taken off the site by Mr. Townsend. Somebody called and said there was a trespasser, and the body later shows up there. The defense is entitled to the instruction that the defendant had no duty to report the crime. Specifically, there must be a factual determination by the jury that the defendant committed the crime. So we're entitled to that instruction, and the state's vague statement to the otherwise is not supported.
All right, I'll grant the request. Where would the parties like to have it? When would the parties like to have it read?
Your Honor, should probably go after the self-defense instruction.
All right, is that acceptable, Mr. Wiggs?
Yes, sir.
All right.
It is.
All right, I will read it after the self-defense instruction. State, please include that.
Yes, sir.
And I think we have the verdict forms remaining. We have count 1 and count 2. Count 1, is it acceptable as drafted? Yes, sir.
Let me find it again. Yes, sir.
Okay. And so verdict form count 1 is acceptable to the defense. Verdict form count 2 as presented.
Judge, I'm going back. Let's go back.
Yes, sir.
As to the verdict form. Was the defendant in actual possession of a firearm? I think you need to put the language in there that was used in the commission of this crime. She's not guilty of just having a firearm in the house.
Well, no, that's not.
And
So it says if you checked A, please answer the following questions. So clearly, if the jurors determine that Ms. Shaver is not guilty of second-degree murder, they do not proceed to 1, 2, and 3.
okay.
So as phrased, it is appropriate and properly worded.
Okay. You're good with that.
All right. Then we're on to count 2.
That's fine, Judge, count two.
All right. And I believe that concludes the jury and, excuse me, jury instructions. Is there anything further?
Yes, sir. As it relates to accessory after the fact, and the way the standard instruction is tailored discusses the fact that the level of the accessory after the fact is tied into the underlying offense that they were being an accessory to. That's why I included the accessory after the fact of manslaughter. I suppose I actually need to change that to accessory after the fact to manslaughter with a firearm, and then accessory after the fact to manslaughter on the verdict form. That also does mean I have to include accessory after the fact instructions that refer to the manslaughter instruction. We will add that as lesser included to the accessory after the fact of secondary murder, and we'll submit those with our final instructions.
All right. And the numbering or lettering on the verdict form as to count two, there's a D in there. It should be a C.
Yes, sir.
Okay. All right. Anything further?
Nothing, Judge.
Before we call the jury in, let's take a 5-minute comfort break.
Thank you, sir.
All right. Thank you. are we ready for the jury?
I just want to ask you.
Yes, sir.
To bring the jury in. I asked Mr. Coluccio who his witnesses would be. It looks like there's a couple witnesses that have been engaging in social media on this cause.
All right.
Okay, if I can approach witness.
And what are their names?
Well, Mr. Philmore said his wife doesn't go by.
Do you want the sidebar to go on, or do you want?
Oh, I don't care.
Okay.
I want to do it here. That's okay.
All right.
There's Miss Philmore.
Rebecca Urbanowski is the witness we're
Right.
referring to.
She goes on social media by Philmore. Okay? And to make that abundantly clear, we have a picture of her. Okay? Using the name Philmore. Miss McManus, she's on the internet as well.
Her first name?
Rena R-E-I-N-A. Gary, they're both present. You can inquire when they have a wash day at the testimony, and then we can make our determination.
Here's the timeline set
All
forth.
right.
That was after the pretrial. And here is Miss McManus is 2 hours from the date on that.
Would you like to bring them in individually?
Yes, sir. Let's do that.
Can you get Rena first, please?
Please come up to the witness stand. Good morning. All right, please be seated and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus.
Okay. Please,
Rena is R-H-I-N-A, McManus, M-C-M-A-N-U-S.
thank you. Please raise your right hand. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And have you, yesterday or during this week, viewed any broadcasts of the trial?
No.
Okay.
Only like during the weekend when they were picking the jurors on the news, but nothing
So
specific.
only over the weekend, okay? But no picking or selecting of jurors occurred over the weekend. That began on Monday morning, okay? But so you did view some broadcasts regarding the case prior to trial,
Just listening to that they were going to pick and this was going to happen, but that's it.
okay? And did you go on social media and post anything concerning the case?
No, sir.
Okay. Did you view anything about the case on social media?
No, sir.
All right. Does the state wish to inquire?
Mrs. McManus, anything that you have seen at this point, would that be news reports about the case?
Not news reports, just like, I'm sorry, just stating news over like Channel 9, stating that like there was a trial going to begin and that's it.
There has been live stream of testimony from this case on Court TV and maybe other sources. Have you watched the testimony of any of the witnesses that have testified this week?
No, sir.
Nothing further, Judge.
Mr. Wiggs?
Yeah, the rule of sequestration was invoked at the pretrial, and the evidence we submitted to the court shows that she has been engaged looking at and discussing the matter with other people on the internet. We believe that is a violation of the rule of sequestration. And
Do you have that document? Show that document to the witness, if you would, Mr. Wiggs. It's up here. You may approach.
McManus?
Yes, sir.
This shows communication on a date specific at the top of this, and communications transpiring, correct? And your name is on that document,
Down here, sir?
correct?
Yes.
Okay, and there's discussions about the case. on a particular date referenced from this communique, correct? So while this court case was open and the rule had been invoked, there was to be no discussions by any witnesses and no review of social media. When did you look at this?
I did not, sir. But
Okay.
my,
Let me ask, why does it
Yes.
have your name on it?
because my daughter and my husband, they all use my phone.
Okay.
But I did not, because I got an email from somebody from the state attorney saying not to look at that. And that was, I think, on Tuesday or Wednesday,
Okay.
something like that.
And you have abided by that request, correct?
Yes, sir.
Okay. All right.
I think that's sufficient, Judge. The state wants us to assume just because there's an internet browser in this household, nobody else had access to it, and nobody else could internet it or enter that same site. That's the inference they want to inform the jury about. I'm not satisfied. I'd ask that Ms. McManus be excluded.
All right. Anything further from the state?
Can we excuse, is there going to be any more inquiry of Ms. McManus? Should we
Yeah.
excuse?
State have any inquiry?
Let me ask.
I have no more. I do have cases in the rule. I'm just, if Ms. McManus can go back outside.
Mr. Wiggs asked for a minute to
One moment.
review documents. He may have some additional questions.
Wednesday, 11:55 this week, correct?
11:55. I don't know. I do have my phone and I can.
Okay. My client has her phone record showing that. Judge, I don't, but we know it's during this week time. That's when we found it and discovered it. She's acknowledged that people within the household, she declares, were using her phone. I'm not satisfied with that. Yes. And my client has her phone records.
All right. And Ms. McManus has testified under oath that it was not her, but a family member.
Right. That doesn't seem to jive with the state when my client testifies to those same facts, Judge.
Is there any more inquiry for Ms. McManus?
Anything further, Mr. Wiggs?
No, thank you.
You may step down from the witness stand. Thank you.
Your Honor, I do
Please
have...
remain outside the courtroom.
I do have the Florida Statute 90.616, which deals with rule of sequestration, along with Hines v. State 719 Southern 2nd 358. Provide those to the defense and the court. The rule of sequestration only extends to the viewing of testimony. Watching news reports or anything like that is not contemplated by the rule of sequestration. And in Hines, the court points out that the appellant correctly, this is from Head Notes 1 and 2, appellant correctly argues that the trial court erred when it applied the sequestration rule as a strict rule. A trial court must first determine whether the testimony of a witness would be substantially different after having heard the testimony of other witnesses in violation of the rule. Should determine whether the violation was intentional or inadvertent, and if intentional, whether it was the witness, party, or attorney who acted in bad faith. Once it has been determined that the circumstances surrounding the violation, the trial court may then exercise its discretion in deciding whether or not exclusion of the witness is necessary. In this case, the testimony of Rena McManus, she is the teacher of Isabel Shaver during the calendar year in question, and she's just going to testify about the child's demeanor, and that there was never any period of time where there was any sort of change. And also I have the school records of Isabel showing her attendance, her grades, things of that nature. So there's no evidence that she has actually viewed any testimony in this case. Whether or not she or someone in her family liked a post about the case does not warrant exclusion in this case.
All right, Mr. Wiggs.
To the court judge, the data, the information she's looking at is court TV. It's not just a little blog from one person to another. The heading directs that she's observing this, but that she's observing the trial matter as it's proceeding. It's not just a little blog from one person to the other. So I believe the witness has violated the rule, and she should be excluded.
The motion to exclude is denied. As to Ms. McManus. Now we're on to Ms. Urbanowski. Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Are you all set? Okay. Please state and spell your full legal name.
My name is Rebecca Urbanowski. It's Rebekah. Last name is Urbanowski.
And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please proceed.
Ms. Urbanowski, have you viewed online any of the testimony of any witnesses in this case?
No, sir.
Did you have a Facebook profile?
Yes. A business and a personal, yeah.
And there was a reference, I believe it might have been a like on a Court TV post with your Facebook profile liking the post. How did that come to be?
I'm not sure. I scroll pretty fast when I'm going through Facebook, and a lot of the news channels were covering this. If I might have hit that, then that's my fault. I don't know, but
Even if you were to like posts such of that nature, that doesn't necessarily mean you viewed the video on it, correct?
correct. No, I did not.
Have you viewed any of the testimony in this case?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs.
Have you been looking at court TV?
I've seen some, not this week. I've seen some, not this week.
That's your name, Rebecca Filmer?
Yeah, that's me.
Okay. And Rebecca Filmer on this one, correct?
Yeah, that's me.
And that says Court TV up there, correct?
Yeah, that says Court TV.
Okay. You go by Urbanowski?
That's my legal name, but I go by Filmer.
Okay. Okay, we heard different from your husband this week. But this would have been Wednesday, 4:37 this week.
Okay.
Is that correct?
If that's what it says.
Is that correct? You think? You don't know. Okay. Judge, we'd ask these be admitted into evidence,
It's fine.
and because of the questionable nature,
Well, as far as the hearing, that is fine.
All right.
and because, yeah, correct.
So admitted into evidence as to the hearing only, not as to the trial. And what exhibit are we up to?
I think this would be Exhibit 1 for purposes of the hearing.
Purpose of the hearing, it'll be a composite of 3 documents. It'll be Defense Exhibit A. It'll be entered into evidence without objection as defense number 1 for the purposes of this hearing only.
I don't have any further questions this morning to the court.
All right, and please proceed. Further questions?
No further questions.
Okay. All right, you may step down from the witness stand. Please remain on standby outside of the courtroom. Thank you. All right, proceed with argument, Mr. Wiggs.
Because of the sensitive nature of the case and the clear instructions of the court to every juror and the obligation of the state, and this matter has proceeded more than once throughout the trial, the state has had ample opportunity to properly advise the witnesses not to be talking. I know the court repeatedly questions the jurors whether or not they should look at, that they don't look at anything. This woman was not responsive and not definitive as to those questions. Yet we have physical evidence that's now in evidence that she has been viewing objects. We ask that she be excluded from this cause.
All right, state's position.
She gave definitive evidence that she has not actually viewed any testimony of the case. That is what would invoke the rule of sequestration in the inquiry, and there has been absolutely no testimony about how that would have impacted or altered her testimony in any way, even if it had been viewed, so therefore the request should be denied.
Motion to exclude is denied. Is there anything further before we call the jurors back in?
No, Your Honor, not from the defense.
State?
No, sir.
All right, let's bring the jury in. Thank you. Please be seated. I see that all of the members of the jury have returned. Thank you again, members of the jury, for your time, attention, and patience today. And I have a few questions for you before we begin. Did any of you speak with anyone or each other about the case? Okay, everyone has answered no. Did any of you view any media, news reports on the internet, anything about the case? Okay, everyone has answered no. Did any of you conduct any research concerning the case? All right, all jurors have answered no. Did any of you encounter or speak with any of the attorneys who are present in this case? Okay, all of the jurors have answered no. Anything further from the defense or the state? All right, then the defense has rested. State, you may proceed.
State calls Rena McManus.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus, RHINA-MCMANUS.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Can you please introduce yourself to the jury?
Hi, my name is Rena McManus.
Do you know Isabel Shaver?
Yes, I do.
How do you know her?
She was my student at Pine Ridge Elementary.
And what year was she in your class?
She was in my class in 2016.
Would that be the school year then going from 2015 into 2016?
Yes, it is.
Now, what grade did you teach then?
First grade.
How old are students in first grade generally?
Generally 6 or 7 years old.
And did you know Laurie Shaver?
Yes.
And what about her father, Michael Shaver?
Yes.
And how did you know them?
I had met, they were parents of Isabella, obviously, but I had met them both, meet the teacher, that school year.
And both Michael Shaver and Laurie Shaver attended that event?
For meet the teacher, yes.
And how were they acting during that time?
Normal parents, inquisitive about how the year would be, wanting to find out about me and the curriculum. It was very pleasant.
Now, over the school year and you were dealing with Isabel Shaver, did she have good attendance?
Yes.
Good grades?
Yes.
And did you ever notice any issues with her?
No.
Was there any time that you saw some sort of behavior change in her?
Not at all.
Any time where she appeared to become more withdrawn or acted in a different way?
No.
Could I go ahead and at this time admit the records, school records of the children, showing defense states MMM for identification. Where the state moves into evidence, states MMM as the next numbered exhibit. It's a business record with the proper business record certification and notice.
I believe we're up to 65, correct? Okay, thank you. Any objection?
Judge, no objection.
All right, without objection, states MMM will be admitted into evidence as states number 65.
And I'm showing witness red number 1205 on the bottom. You recognize these as the records for Miss Shaver while she was in your class.
Yes.
And does that confirm everything you've been saying about attendance, grades, no behavior problems, things of that?
Not at all. Yes, it does.
Throughout your teaching experience, do you encourage students to talk to you if they have any sort of problems?
Yes, of course.
And did she ever talk to you about any issues that she had at home?
Never.
Did you also teach her brother Aiden?
Yes.
And when was that?
2 years later.
And how was his behavior when you were teaching him?
Just like hers. Sweet.
Nothing further, Judge.
All right, thank you. Mr. Wiggs?
How old was Isabel?
7.
7 going on 8?
I'm not 100% particular about her birthday.
Correct. Okay. What degree do you hold?
I have a master's in education,
Anything else?
my teaching degree.
Okay. You have a degree in psychology?
No, sir.
Okay. How large is your class?
Usually from 17 to 20.
Okay. So you're talking about the mindset of Isabel Shaver, correct?
Well, I'm talking about not her mindset, but the behavior that I witnessed.
Right. Okay. And your mind may reflect your behavior to a sense, correct?
Correct.
Okay. Your behavior actually may be shielded by other events in your life, correct?
My behavior?
No, anybody's.
Oh, yes.
Okay. They may want to lock up. They may want to be quiet, correct? Isabel was relatively quiet, was she not?
Yes.
Okay. Do you hold any degree in psychology?
No, sir, I don't.
Any degree in sociology?
No, sir, I don't.
Okay. How large is your class?
It goes from like 16 to 20 students.
How many sit-downs did you have with Isabel Shaver on a one-on-one?
Many.
Any?
It's all academic, so we do small groups. So,
No, I'm not talking about a small group. I'm talking about you on one-on-one with Isabel Shaver.
in what manner, sir?
I'm just asking you, did you have any one-on-one sit-downs with Isabel Shaver?
In processing education, the way we teach, yes, sir, I did.
You sat with Isabel Shaver individually, without anybody else around.
That's not what I'm understanding
I
from you.
don't know.
So I have
What?
never.
No, ma'am. Let me ask.
Objection.
Please allow the witness to finish answering. You may finish your answer.
Sitting on a one-on-one in a room isolated, that's not what we do.
Correct. I don't care about what you do, I'm just bringing that point out. You didn't do that.
I think you should care about what I do because I'm a teacher.
Ma'am, I'm bringing out a point.
Okay, sir.
You're not sitting there with Isabel Shaver doing any kind of psychological analysis.
No, sir, that's not my job.
Okay. You don't have a degree to do that, correct?
No, sir, and I would not.
Correct.
Thank you.
All right, State.
Mr. McManus, would you have individual conversations with all of your students throughout the course of a year, although other students may have been present in the room?
Yes.
Nothing further, Judge.
Thanks. We have no further questions.
Should she be released from our subpoena?
Yes, sir.
All right. Thank you for appearing today. You're released from further testimony. Have a good day.
The state calls Jared Strickland.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Good morning. All set? Okay. Please state and spell your full legal name.
Jared Strickland, JARRODSTRICKLAND.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
At this point, I'm pretty sure the jury knows you, but can you reintroduce yourself?
Sure. Corporal Jared Strickland, the Lake County Sheriff's Office.
We've been having various discussions about Facebook profiles. The last section I want to cover with you did you view various pictures of Laurie Shaver's child, Isabel Shaver, from November of 2015 through May of 2016 on Laurie Shaver's Facebook?
Yes, I did.
Showing defense was previously been marked for identification as states NNN. Showing the witness was previously been marked for identification as states NNN. Do you recognize those photos?
Yes, I do.
And are those photos from the Laurie Shaver Facebook profile that's already in evidence?
Yes, they are.
Sure. At this time, the state moved NNN into evidence as the next numbered exhibit.
All right, that would be 66. Any objections?
Yes, Judge, a standing objection as to the motion regarding digital data and the relevance issues we've raised previously.
All right. The objection is overruled. States NNN will be admitted into evidence as states number 66.
And Detective, if it's easier to just reference the posts from the packet I gave you. Go ahead and publish a bit for you guys. So this first photograph that we are looking at, when was that posted?
November 18th, actually November 16th, 2015.
So approximately 6 days, approximately a week after the last known sighting of Michael Shaver.
Correct.
Moving on to the next post. When was this photograph posted?
November 21st, 2015.
We have a series of I believe this is about 6 photos. When were these posted?
Are these the pictures with the cookies?
Yes.
November 22nd, 2015.
And that would extend on to the picture that appears to have a gummy worm coming out of her mouth, out of her nose.
I don't know if I'm in order. Can I see the screen?
Yes. This photo here is part of that same April post, correct?
Yep, there it is. I believe that those are, sorry, the dates are out of whack. It looks like the end of March 2016.
And then the photos here, first of all, this post that starts with page 1828 goes on to the photo 1829. Do you have a date for the post? Actually, I believe it goes over to, when were these photos posted?
May 3rd, 2016.
Finally, picture of her in the black dress and the post that went along with that. When was that posted?
May 19th, 2016.
Going back to the excavation of the Shaver residence, were you involved with contacting Ms. Shaver after the warrant had been completed?
Yes, I was.
And how did you contact her?
By phone.
So she was not in any sort of custody.
That's correct. She was not.
And when you were calling her, what was the purpose of that call?
To let her know that we were finished with the search warrant and that she could return to the house, and also to let her know the items that we had taken.
And at that time, were you asking her any questions, or were you just informing her of those facts?
Just informing her of those facts.
Showing the defense what has been previously been marked as states AAA for identification. Showing the witness states AAA. Do you recognize that?
Yes, I do.
And what is it?
This is a CD copy of the phone call that I made to Ms. Shaver.
How do you recognize that guy?
It has my initials on it.
And have you reviewed it and listened to it before initialing that?
Yes.
Is that a fair and accurate reporting of that conversation?
Yes, it is.
Sure. At this time, the state move states AAA into evidence as the next numbered exhibit.
Is there any objection?
No objection. Lead to subject irrelevance.
Objection is overruled. States AAA will be admitted into evidence as states number 67.
You're going to ask to publish?
Permission granted.
completed paperwork, a HP laptop, additional swabs, SD card with photos belonging to the Lake County Sheriff's Office, possible buckshot beatings, projectiles, unfortunately this is a word that I cannot read, and human skeletal remains. So as far as all of that stuff goes, do you have any questions? Okay.
During this phone call, did you inform Ms. Shaver there was human skeletal remains found on the property?
I did.
Did she react in any way?
No, she just said okay.
There was some mention of a computer, some SD cards, things of that nature. Were those ultimately reviewed to see if there was anything relevant about the time frame of this homicide?
Yes, they were.
And was there anything relevant on those various electronic items that were?
There were not.
Nothing further, Judge.
Mr. Wiggs?
Yes, ma'am, please support.
May it please the court.
Yes, sir. Please proceed.
Deputy,
Corporal.
Corporal, sorry. You were quite polite on that call, correct?
Excuse me, I can't hear you.
I believe you were quite polite on that phone call, don't you?
Yes, sir, I do.
I believe that Laurie Shaver was quite polite on that phone call, don't you?
Of course.
And I don't believe we heard any confession of a crime or any implication of any guilt on that phone call, do we?
To repeat what I've tried to say for the last 2 days.
No, sir.
Whenever you take
No,
all
sir.
of the evidence as a whole,
Sir, please answer the question directly.
As to this phone call, do we hear any confession of guilt?
I didn't ask her.
No. Do we hear any confession of guilt?
No, sir, you do not.
Very well. Thank you.
Thank you. State? All right, sir. Thank you for appearing today. You're excused from further testimony. Have a good day.
State calls Kendall Davidowski.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Kendall Davidowski, KendallDavidowski.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Can you please introduce yourself to the jury?
Kendall Davidowski.
Did you know Michael Shaver?
Yes, I did.
How did you know him?
We originally worked together at Spaceship Earth over at Walt Disney World from November of 2014 till about May of 2015.
And what was your position with Disney?
I was an electrical apprentice at the time. He was a mechanic.
And at the point that you met him, where was he living?
He was living at the Warbirds hangar in Kissimmee.
What is that?
It's a airplane hangar, I mean.
And do you know Laurie Shaver?
I know of her, yes.
And what was, at the time that you met Michael Shaver, well, let me ask you this, at some point did you start a dating or physical relationship?
Yes, we did.
And what was the status of his relationship with Laurie Shaver while he was living at the hangar?
They were separated at the time.
Now, are you aware of what caused Michael to separate and move into that hangar?
I was told...
Based on hearsay?
State response.
Your Honor, can we approach?
Sidebar, please.
you aware of the events that led to why Michael Shaver was living in Woodward?
He had told me why he was, yes.
And was that related to his arrest for domestic violence?
Yes, it was.
Now, did he talk, and I'm not going to ask you to say this, what he told you about that event, but did he explain what had happened that night to him?
Yes.
Based on that, did he express fear of Laurie Shaver for his safety?
Yes, he did.
And could you explain that?
He was concerned of his safety and the children's safety with Laurie and a gun.
Laurie, what?
And her having a gun.
Now, did you ever see Michael Shaver interact with his children?
I saw him interact with his son, Aiden, once.
And how was that?
They seemed to get along very well.
And at some point did your dating relationship with Michael end?
Yes, it did.
And when was that?
About April of 2015.
And who ended it?
It was kind of mutual decision. It was just becoming too much at that point.
And at that point, was he trying to reconcile with Ms. Shaver?
To my knowledge, yes.
Did you remain friends with him?
We weren't friends. We still worked in the same area, so, I mean, we were cordial, but we didn't speak to each other.
After he went missing, did you make attempts to reach out to him to see where he might be?
Yes, somebody from Spaceship Earth had contacted me, seeing if I had contacted him or heard from him. I had not, so I reached out to him around November of 2015.
And did you ever hear from him?
I believe he said that he had left and that his children, or he just left the children. But at that point, I didn't know if it was actually him or not.
You had, well, first of all, was that a phone call?
It was through Facebook. It was through Facebook Messenger.
And had you interacted with him in Facebook before?
Previously, before May, yes.
And did you, when you guys were dating, did you also exchange text messages?
Yes.
Was there anything unusual about the contact that you had with him and the content of it?
It just didn't seem like him to just up and leave. He spoke so highly of his children, so I didn't see that happening. And it was very short. It was just all very short, one-word answers, so that was not usually like him.
And have you ever initiated any sort of sexual harassment claim against him?
No.
Nothing further, Judge.
Mr. Wiggs?
Yes. You never filed a sexual harassment claim against Michael?
No, I did not.
You know anybody that did?
I had a sexual harassment claim filed against me.
You're sexually harassing people?
Supposedly, yes, according to
Okay.
Disney.
How long did you date Michael?
From about, I would say December of 2015, December of 2014 to April 2015.
So you heard Michael's version of events,
Yes.
correct?
Yes.
Did you see any did he show you any photos of any battered women?
No.
Did he show you any police reports involving Michael Shaver? Okay. Did you ask him about that?
We had a brief conversation about it.
Okay. Did you ask him about any involvement with law enforcement or any agencies?
No.
You know who killed Michael Shaver?
I do not.
Thank you.
Redirect?
Ms. Kavadowski, was anyone involved with this case involved with making that claim against you?
According to Disney, it was Laurie Shaver.
Okay. Nothing further, Judge.
Any follow-up?
No follow-up.
Thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Robert Sellers.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
I'm ready, sir.
All right. right, please state and spell your full legal name.
Robert Sellers, R-O-B-E-R-T, last name Sellers, S-E-L-L-E-R-S.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Please proceed.
Please introduce yourself to the jury.
My name's Rob Sellers. I'm currently an FBI agent. I was a Lake County Sheriff's Office deputy for 5 years, and that's how I'm involved with this case.
In 2014, what was your position with the Lake County Sheriff's Office?
At that time, I was on road patrol, assigned to Sector 3, which is the southern portion of Lake County.
And what will your duties be as someone on road patrol?
I'm his road patrol, just like the guys and gals that are on the street now, responding to 911 calls and answering calls for service in the southern portion of the county.
Now, did you have an opportunity to come into contact with Laurie Shaver and Michael Shaver in September of 2014?
Yes, sir, I did.
And were you the arresting officer of Michael Shaver from the domestic violence incident that has been discussed in this case?
Yes, sir, I was.
And when you got there, did you speak with both Laurie Shaver and Michael Shaver?
I did. I spoke with Laurie first and then ended up making contact with Michael a little bit later on.
Is it fair to say that their stories contradict?
Yes, sir.
Now, were there photographs taken of both Laurie Shaver and Michael Shaver, along with some things that happened, conditions within the house?
Yes, sir. I believe Deputy Suttles took those photos.
I'm showing defense, which has been previously marked as states QQQ.
All right, sidebar, please.
Witness, what's been labeled as states QQQ. Do you recognize those photos?
Yes, sir, I do.
And what are those photos?
Those are photos that were taken the night of September 4th when we responded to, I guess the first couple photos are from when we met Laurie Shaver in the Target parking lot in Claremont, and then the last couple photos appear to be when we met Mr. Shaver at the residence, and photos of the residence itself in Claremont.
Do they fairly and accurately depict the things that you had photographed as part of your identification in this case back in 2014?
Yes, sir, they do.
The state moves to states QQQ as evidence is the next numbered exhibit.
All right, Mr. Wicks, without objection. Without objection, states QQQ will be entered into evidence as states number 68.
Go to push. Move this back. This photo number 1 from states QQQ. Who is that?
It's Laurie Shaver.
Photo number 2. What does this photo depict?
The photo of her left arm,
Photo number 3.
her right arm.
And photo number 4. Who is this?
Mr. Shaver.
And during the course of your investigation, did you observe any sort of laceration to his head?
Yes, sir.
Photograph number 5. Does that demonstrate that laceration?
That would be the laceration, yes, sir.
And photograph number 6. What is depicted here?
Their residence.
Photograph number 7. What is shown in this photograph?
Broken door to their residence.
Did Laurie Shaver give you any explanation about how that happened?
I don't recall.
Photograph number 8. What is that photograph depicting?
I believe it's the other side of the same door.
Photograph 9.
2 firearms that were involved in the altercation.
Photograph 10.
Be the bathroom.
Was that all the various areas of damage that occurred?
Yes,
That you took photographs of?
To the best of my recollection, yes, sir.
There's also some sort of indication of an entertainment center that was damaged. Did Laurie Shaver give you any explanation about how that happened?
Not that I recall.
Any explanation of the broken vase that
Not-
went along with the slide glass door?
There was, but I think there was a story from Mr. Shaver about how that had occurred.
But Ms. Shaver gave you no.
No, it's not that I recall.
Did Laurie Shaver give you any explanation of how Michael Shaver got the injury to the top of his head?
Yes, sir, she did.
And what was that?
She stated that Michael had the pistol in his left hand and that they'd fought over the pistol, and while they were fighting over the pistol, it somehow went up and struck him in the head.
Did Mr. Shaver have contradictory version of events?
He did.
Were there any adult witnesses present when any of this happened?
No, sir.
No. Were there any attempts to talk to any of the children in this case, specifically the oldest child, Isabel Shaver?
There was, yes, sir.
Was she able to tell you anything about what happened?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs?
Can we move this, Nick? Madam Bailiff?
I got it.
I'm receiving a call and I apologize.
I'm sorry, what do you, may it please the court?
Yes, sir.
What do you go by now? What's your,
I go by Rob, but my legal name's Robert. Yes, sir.
okay, I know you're with the FBI now.
Yes, sir.
What's your title over there?
Special agent with the FBI.
Special agent, okay. What do you want me to call you? Special agent? Rob, okay. Rob, when this event transpired and you went to the scene, where was Miss Shaver?
She was on her way to the substation in Claremont, and she was told by dispatch to stop where she was at, which I believe was the target located off 50 in Claremont.
Right. Miss Shaver's the one that fled the residence for her safety, correct?
From my understanding, yes, sir.
Correct. Miss Shaver's the one that fled the residence with the children to protect those children, correct?
Yes, sir.
Very well. Thank you.
All right, redirect.
No, sir.
All right, thank you for appearing today. You're released from further testimony, and have a good day.
Thank you, sir.
Yes, sir.
State calls Weldon Nicholas.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Wilma Nicholas, WILMANICHOLAS.
And please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please proceed.
Can you please reintroduce yourself to the jury?
Hi, I'm Wilma.
Now, in September of 2014, was there a disturbance at your neighbor's house, the Shavers?
Yes.
And how did you become aware of that?
When I arrived home from work around 6 o'clock, Mike called me on my cell phone.
Not getting into anything specific that he said, but did you go over to his residence at that point?
Yes.
And when you met with him, how was he acting?
He was kind of frantic, distraught.
Did you observe any injuries to him?
Yes.
What was his demeanor? Was any, you said distraught, anything?
He was really concerned.
Did he still appear to be under the effects of the event that placed him into that condition? Was he still troubled by whatever caused his injuries and things of that nature?
Not so much of his injuries as something else.
Just for the record, I'm going to object on Williams' basis, under the Williams rule, the matters that we previously addressed at the court.
Yes, sir. State?
Can we approach?
Yes, let's have a sidebar. Thank you.
So while Mr. Shaver was in this excited state, did he describe to you what had happened?
Yes.
What did he describe to you that happened?
He told me that they had had an argument. Laurie was intoxicated and she had taken off with the kids. The injuries that I saw on him, he said that she had threatened to kill the children, him and herself, and he fought her with the gun and was trying to get the gun away from her, and she hit him over the head, the top of the head with the gun.
Did you see injuries consistent with that?
Yes.
Did you take pictures of those injuries?
I did.
Showing the defense what has been previously marked for identification as states 000. Showing the witness states 000. You recognize these photos?
Yes.
And what are those photos of?
Those are the pictures that I took of Michael and his injuries and his torn clothes.
Does that accurately reflect how Michael Shaver was when you observed him that night after you described the events that you've talked about?
Yes.
At this time, the state moves states 000 into evidence. That's the next numbered exhibit.
Mr. Wiggs, any objection?
Same objection, Judge Standing.
Objections overruled. States 000 will be admitted into evidence as states number 69.
The time frame that you knew Mr. Shaver, what was his approximately height and weight?
He was about 5'6", almost the same height, I think, as me, and about 150 pounds.
I'm going to go ahead and publish photograph number 1 from the previous exhibit. What were you trying to show with this photo? Can you see it?
Barely.
Let me turn it.
Okay. You can tell that he has blood coming from the top of his head and it has come down onto his shirt. His shirt has been torn in multiple areas here in that photo.
And the tearing of the shirt, did he attribute that to Laurie Shaver?
Yes.
Photograph number 2.
Here
What is depicted here?
you can see the top of his head and the injury a little bit better here.
And did you take a top view of that in photograph number 3?
Yes.
Photograph number 4, what are you showing here?
He had the keys to her truck in his pocket, and she was fighting him and tore his shorts to get the keys out, and she succeeded in getting the keys out.
And did he express why he was trying to prevent her from having those keys?
Because she was drunk and she was taking off with the children.
Nothing further, Judge.
All right, Mr. Wiggs.
Please, the court.
Yes, sir.
Do you know who was charged out of this incident with any criminal offense?
Yes,
Who?
Mike was.
Correct. So you get Michael's version of the events, and only Michael's version, correct? Correct, ma'am?
Yes,
And Michael ends up being prosecuted, correct?
he does.
Okay. So you would agree the state attorney's office had a different opinion.
Objection, Your Honor. Charging decisions of the state.
Sustained.
So evidently, people were dealing with Michael Shaver. Michael Shaver ends up prosecuted, correct?
Based upon,
Ma'am?
yeah,
Correct?
yes.
Okay. So what you got is a one-sided interview with Michael, correct?
I have heard her myself.
No, ma'am. You spoke to Michael, correct?
Yes.
Okay. Did you interview Laurie Shaver?
No.
Okay. Do you know who the initial aggressor was that caused that injury to Michael Shaver other than what Michael Shaver told you?
I wasn't there in person.
Correct. Correct. Thank you.
All right, redirect.
Yes, sir.
All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Rebecca Urbanowski.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to proceed. Thank you. All set? All right. Please state and spell your full legal name.
It's Rebecca Urbanowski, REBEKAHURBANOWSKI.
All right. Thank you. Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
I am Rebecca Urbanowski.
And do you know Laurie Shaver?
Yes, I do.
How did you meet Laurie?
I met her at the gym through her boyfriend at the time.
And did you work for the gym?
Yes, Gold's Gym in Claremont.
And what position did you have there?
I was a personal trainer there.
And when you say her boyfriend at the time, who was that?
Jeremy Townsend.
Did did you ultimately start a professional client-trainer relationship where you were training her?
Yes, I did.
And what was her general physical status at that point?
She was in pretty good shape. She had lost a substantial amount of weight on her own already, but she was in good shape, better than most, new clients that I get.
Was she doing strength training?
Yes, we train twice a week.
And do you know Travis Filmer?
Yes, I do.
How do you know Travis?
That is my brother-in-law now.
Who is your husband?
My husband is Austin Filmer.
And when did you get married to Austin?
October 28th, 2016.
Now, did you legally take his last name?
I did not.
So on your driver's license it says Rebecca Urbanowski?
It still says Urbanowski, yes.
Have you ever had any sort of social media profile where you had the Filmer last name?
Yes, I have, yeah.
But if it were said that you never took his last name, that would be a correct statement.
Legally, no, I never took it.
Did you ever socialize with Laurie Shaver and Travis Filmer?
Yes, I did.
And when did they start dating?
I don't know a specific date that they started dating, but I know that they were in contact after they had initially met and hung out.
When approximately did they meet and start hanging out?
They met the first time at the end of February of 2016.
And when was this compared to when she was dating Jeremy?
It was kind of in like that gray area, I think. When Travis and Laurie first met that night, Travis had already had a girlfriend at the time. So after that night, they actually left. We had gone to Old Town, and Austin and I were kind of dating at the time, or starting to date. And both the boys came, and Laurie and I had been there. And when Austin and Travis showed up, Travis felt it was uncomfortable because he had already had a girlfriend at the time. He didn't want it to look like a double date. So they left probably 20 minutes after getting there.
The period of time when she was dating Jeremy, was there like a hard break to that? And then Travis came to the picture, they kind of overlapped. What was the deal there?
They kind of felt like they overlapped. So it was kind of a gray area when one stopped and then the other one officially began.
At some point, did you live with the defendant?
Yes, I did.
And is that at the residence in Claremont?
The Sandy Pines, correct, yeah.
And when did you start living with her?
That would have been May 7th, 2016.
And at any point while you were there, would Jeremy come over, stay overnight, or anything like that?
Never overnight. I've only seen him there one time when I was there, but I hadn't moved in at that point.
And like, what kind of day are we talking about when Jeremy would come over?
It was during the afternoon time.
Around her lunch break?
Yeah, I would say so, yeah.
And while you were living there, did you see Laurie with multiple phones?
Yes, I did.
And what was her phone number at the time?
Offhand, I can't say exactly what it was. I just have the one that I have now.
Is that the same number that you had back then, or has that changed?
It would have changed, okay. Yeah.
Now, during the time that you were friends with Laurie Shaver, was a concrete slab put in the backyard around a fire pit?
Not when I initially moved in, no.
Were you friends with her and socializing with her when that occurred?
Oh, yeah, sorry, yeah.
And were you and Austin present when the cement slab was placed down?
I was actually at work most of the day. When I got back, it was there, because I worked majority of the day.
During the time frame that Laurie has been with your brother-in-law, Travis Filmer, has the relationship between Austin and yourself changed with Travis?
Very much so. We rarely see Travis anymore. For a while, we couldn't even get in contact with him because we found out that all of our phone numbers were blocked from his phone. Austin and Travis have always been very, very close. They're fraternal twins, and they've been through a lot in life together. They used to go fishing a lot, hanging out, but we don't see anything from him, or we don't talk to him, we don't socialize. The last time I've actually physically seen him was when their grandfather passed away at his funeral. That was the last time I physically saw him.
Did Laurie Shaver ever tell you what happened to her prior husband, Michael Shaver?
Just that he had left.
Nothing further.
All right, Mr. Wiggs?
So y'all have a bad relationship, correct?
Who?
Austin and Laurie and Travis, correct?
There is no relationship.
Correct.
Sure.
So that's what you have to testify here to tonight? That there's a bad relationship? Bad blood?
I guess.
You lived in the residence in a certain period of time, correct?
Correct.
Didn't see a homicide committed there, did you?
No, I didn't.
Didn't see anybody being buried, did you?
No, I didn't.
Okay. And you know there was, she was dating Jeremy for a period of time, correct?
Yeah, for a little bit.
You have sit-downs with Jeremy?
I've seen him once there.
Okay. So he was at the house once. You moved out. What was the time period you moved out?
It was the day after their wedding. So it would have been 2008, January 1st, 2000.
You're talking about Travis and her.
Yeah, Travis and Laurie's wedding, yeah.
So were you back there in the period of time when she was dating Jeremy?
Was I back there? What do you
Were
mean?
you living with Laurie?
When I moved in May, they weren't really dating. It was kind of an up and down.
Thank you.
Redirect?
The wedding that you referred to, that was in, what year was that?
That would have been December 31st, 2016, sorry.
And had that been you were a guest at that?
Yeah, because the next day, we were moving into, Austin and I and Kendall were moving into our new home.
Had that event been represented to you to, in fact, be a wedding?
Yes, it was.
And she was in a white dress?
Yeah, when I had come back from signing our lease and everything, she was already in her dress.
There was wedding cake?
There was a wedding cake, yep, a dress.
Everyone there thought that Travis and Laurie were being married at that time?
For sure.
Nothing further.
All right, Mr. Wiggs?
Nothing?
Nothing. All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Katina Vasquez.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Katina Vasquez, Katina V as in Victor, Asquez.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Yes? Okay. Thank you. Please proceed.
Can you please introduce yourself to the jury?
Hi, I'm Katina Vasquez.
And do you know Laurie Shaver?
Yes, sir.
Do you see her here in the courtroom today and can identify her by something that she's wearing?
A black jacket.
And how did you meet Laurie Shaver?
Through Scott Amatuccio, my ex-fiance.
And do you remember approximately what year you would have met Laurie Shaver?
I believe we started dating 2006, 2007, and we ended the December 2014.
And did you know Michael Shaver?
Yes, sir.
And how did you meet him?
Through Scott.
And were Scott and Michael Shaver close friends?
Yes.
What was your through meeting Laurie through her friend Mike, did you develop a friendship with her?
Yes, sir.
Did you develop a friendship with Michael Shaver?
Yes, sir.
Closer friends with her than Mike?
Yeah.
And did you ever go over to the Shaver residence after Mike disappeared in November of 2015?
Yes, sir.
And why were you going over there?
She said he had left, and I went over just to see how she was doing.
And did Laurie say anything to you about where Mike was?
No, just that he left in a black SUV in the middle of the night.
And did she reference anything to you about Mike's work or whether or not he was still working there?
That I don't think he was going to work.
And did she tell you specifically how he informed his employer that he was no longer going to work for them? You don't remember anything about that? Mm-hmm. Okay. While you were there, did you see anything that you thought was unusual based on the story that she gave you that Mike had just left?
Yeah, all his stuff was still there.
When you say all this stuff, what do you mean?
She was in the she was on the porch on the phone, and I went to the bathroom, and like all his stuff was like still in the closet and stuff, and the car was there.
Talk about clothes, toiletries, things of that nature? Is that a yes?
Yes.
Okay. Did you see any extra phones in the residence?
There was a black phone on the counter.
Now, while you were there, was the defendant trying to sell or get rid of any of Michael's property?
Yes.
And what was that?
She was on the back porch on the phone and was trying to sell guns, and I asked, why are you selling Mike's guns? Isn't he going to need them? And she said she bought them. They were hers.
Now, were you familiar with the domestic violence case where Mike Shaver was arrested in 2014?
Yes, sir.
And how did you become familiar with that?
Laurie told me.
And what did she tell you about that 2014 domestic violence case?
At her house, she said, because Mike had come back into the home, he was living at an airport, and she said that, and I was kind of like, why is he here, kind of, and she said that she was working with being honest with her therapist, and that Mike didn't touch her, like all the wounds were from her. She threw a vase and broke a door. It wasn't Mike, and he was actually trying to stop her because she had a gun and was trying to kill herself.
When did your friendship with Laurie Shaver end?
2017.
And at the time in 2017 when the friendship ended, did she make any statements to you relating to Michael Shaver still being alive?
Yes, sir.
And what did she tell you?
She was going to move up to Gainesville because I had a son and couldn't afford daycare. And she was going to drive up, look for houses. She got my Starbucks order, took pictures of the kids in the car, and then disappeared. Didn't hear from her for 2 weeks. Took me off Facebook. 2 weeks went by, and she finally got in touch with me and said that she panicked because Mike was in the parking lot, and she thought maybe Scott told Mike that she was coming up there and he was stalking her. And I'm like, well, why haven't you called me? And she said that the cops had her phone and the truck was at the police station because he was tracking it.
And this is in 2017 that she was saying Michael Shaver was stalking her.
Yes.
So clearly after May of 2016,
Yes.
and clearly after September of 2016 when the cement slab was put in her backyard.
Yes.
Nothing further.
Mr. Legs?
May it please the court.
Yes, sir.
Ma'am,
Did you file a letter to support Laurie Shaver on an injunction?
No.
No? You never submitted any letter to DCF?
No.
Did Michael ever obstruct your relationship with Laurie?
No.
Okay. Now, when you said that Laurie was selling property out of the residence, do you have any understanding whether that was only Michael's property or whether it was marital property?
It was.
That she was by law prohibited in any manner?
She just said the guns, and I know the guns were theirs. And
Okay. Do you know anything about marital labor and contribution to the marriage?
no.
Correct. So you just assume this is Michael's property and she had no right to touch it, correct?
They were their guns. He built and restored guns. So
Do you know why the property was being sold?
no.
Do you know if it was maybe the need for groceries and necessities?
No.
Do you know if there was any plan to aid anybody with those funds to escape detection of a crime?
No.
Did you ever witness a murder or any event occur at the house?
No.
Now, the event that you spoke about an incident that occurred at the house, a crime, a battery, were you there to witness that event?
No, sir.
Correct. Thank you.
Redirect. All right, thank you for testifying here today. You're excused from further testimony. Have a good day. Next witness.
At this time, the state of Florida rests.
All right, let's take the jurors out at this point. Have a comfort break. Jurors have exited the courtroom. Are there any motions at this time?
Yes, Judge, we'd renew our motion for judgment of acquittal on same grounds previously stated. We'd also make clear that these acts of violence that have been spoken of have been only offered for prejudicial value against the defendant. There's no probative value. There's no notice. It's not substantive evidence established to prove a prima facie case. It's purely circumstantial. The state supplied the court with case law. In that case law, there's a notation to a 5th DCA decision speaking about any relative probative value can be outweighed by the substantial prejudice that it presents. It should not have been presented to the jury. The digital data that the state relies on is not sufficient to establish causation. It does not establish the nature of the offense. It does not defeat a claim of self-defense. There's been reference to sale of guns. There's no distinguishing that this is non-marital funds, that Ms. Shaver had no right to sell this property, nor does it advance any claim to an accessory after the fact. We'd ask that the court grant a judgment of acquittal on these grounds and all other arguments previously mentioned before the court.
All right, thank you, Mr. Wiggs. State's response?
The state most favorable to, in the light most favorable to the state, there's sufficient evidence to present to the jury.
Motion's respectfully denied when viewed in a light most favorable to the state. The evidence does establish a prima facie case sufficient to support a conviction as to each count and the information. Motion's respectfully denied. All right. And anything further, Mr. Wiggs?
Nothing from the 1 second.
Yes, sir.
The defense has no rebuttal. Thank you, Judge. and we'll
Thank you,
rest.
sir. No rebuttal from the defense. How long will the state take to print out the revised jury instructions?
I have a couple questions for clarification. They're done, Your Honor?
Yes, sir.
Some answers from Mr. Wiggs on a few things. The forcible felonies in the self-defense instruction, you wanted attempted murder and aggravated battery?
Correct.
In order to define what he's a little more specific, I'm assuming you want attempted second-degree murder and not attempted first?
Correct. Well,
Okay.
no, wait a second. I think we've declared, or my mindset is that there is an attempted first on her, by Michael against her, so the elements of attempted first.
Attempted first and aggravated battery?
Correct.
Okay. Do you want the definition or do you want the elements?
The elements.
Yes, sir. Thank you, Judge.
All right. And is there anything further? I will read the preliminary instructions to the jurors when they are called back in.
Rich, how long are you going to put that together?
We need probably about 15 minutes to...
Well, 15-minute break, is that sufficient?
I think so.
Would you like additional time for yourself?
No, sir, I'm good.
15 minutes is good. Okay. I will plan on a 15-minute break. Yes, sir.
Okay, I'm sorry. Do you want to go direct at? What time do you want to take up closing?
Well, and again, there are no time constraints, but for timekeeping purposes, how much time would the parties like?
Usually shorter than the defense, so I'll defer to Mr. Wiggs how long he thinks he needs.
I'll let the state advance first.
Your Honor, I will probably be around an hour. Worst case scenario, an hour and a half for both my initial and rebuttal. But usually not very long-winded.
All right. Well, sounds like combined it might be 3 hours.
I would say, I would, yes, at the most.
And again, please take as much time as you need. Right now it's 10:46. We'll plan on coming back around 11, and I'll read the initial instructions to the jurors at that time, and we can go into the closing at that time. We can break for lunch after. Well, we'll see where we get, and then perhaps after the state's initial closing argument, we'll break for lunch, and then proceed with the defense and the state's second round after that.
Yes, sir.
All right. Anything further? We'll take a 15-minute break. 2020 CM 2361.
Your Honor, I made the appropriate changes to the jury instructions. I would ask that Mr. Wiggs double check especially the self-defense instructions, since there were a lot of changes made to that to make sure it's accurate.
Please let me know once you check the instructions, Mr. Wiggs. And prior to calling the jurors back in, I'd like to have a sidebar with the parties and with the deputy, if you would. Okay.
Yes, sir. Email me that. I got to put that on my point. Oh, he's still looking at that.
Is this my copy?
Yes.
Okay. Dennis, do you have a stapler? Big stapler?
Do you want some paper clip?
Okay.
Paper clip?
I'll find it.
All right, please bring in the jurors. Thank you.
All rise.
All right, I see that all the members of the jury have returned. Please be seated. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Laurie Lee Shaver, the defendant in this case, has been accused of the crimes of murder in the second degree with a firearm and accessory after the fact to second-degree murder. Introduction to homicide. Laurie Lee Shaver is accused of murder in the second degree in count 1. Murder in the second degree includes a lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Michael D. Shaver was killed by Laurie Lee Shaver, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Laurie Lee Shaver may be found guilty of murder in the second degree or any lesser included crime. Murder second degree, count 1. To prove this crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, the death was caused by the criminal act of a Laurie Lee Shaver. 3, there was an unlawful killing of Michael D. Shaver by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. An issue in this case is whether Laurie Lee Shaver did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Laurie Shaver was in fact so provoked and did not cool off before she committed the act that caused the death of Michael D. Shaver. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion, based on adequate provocation, you should find her guilty of second-degree murder. Possession of a...
You should not find her.
Yes, sir. I will read that again. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her not guilty of second-degree murder. Please make that correction. Thank you. Possession of a firearm and discharge causing great bodily harm or death. If you find that Laurie Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm and in doing so caused great bodily harm to or the death of Michael D. Shaver, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Laurie Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Laurie Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. The frame or the receiver of any such weapon, any firearm, muffler, or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means the defendant, A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included offense. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Michael D. Shaver is dead. 2. Laurie Shaver intentionally committed an act or acts that caused the death of Michael D. Shaver. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm. If you find that Laurie Shaver committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Laurie Shaver committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find her guilty only of manslaughter. Accessory after the fact to second-degree murder. To prove the crime of accessory after the fact to second-degree murder, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a murder in the second degree was committed by another. 2, after the murder in the second degree was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at the time Laurie Lee Shaver knew that other person had committed At that time, Laurie Lee Shaver knew that other person had committed the murder in the second degree. 4. Laurie Lee Shaver did so with the intent that other person avoid or escape detection, arrest, trial, or punishment. The elements of murder in the second degree have previously been given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of accessory after the fact to second-degree murder is accessory after the fact to manslaughter. Accessory after the fact to manslaughter. To prove the crime of accessory after the fact to manslaughter, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a manslaughter was committed by another. 2, after the manslaughter was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at that time, Laurie Lee Shaver knew that the other person had committed the manslaughter. 4, Laurie Lee Shaver did so with the intent that the other person avoid or escape detection, arrest, trial, or punishment. The elements of manslaughter have been previously given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment. Nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. Justifiable use of deadly force. It is a defense to the crime of murder in the second degree, including lesser included offenses, if the actions of Laurie Shaver constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Laurie Lee Shaver does not have the burden of proving that she was justified in using or threatening to use deadly force, or that Isabel Shaver was justified in using or threatening to use deadly force in the defense of Laurie Shaver. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force in Florida is as follows. Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel Shaver was justified in using or threatening to use deadly force in defense of Laurie Shaver, if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The elements of attempted first-degree murder are: 1. Michael D. Shaver did some act intended to cause the death of Laurie Shaver that went beyond just thinking or talking about it. 2. Michael D. Shaver acted with a premeditated design to kill Laurie Shaver. 3. The act would have resulted in the death of Laurie Shaver, except that someone prevented Michael Shaver from killing Laurie Shaver, or he failed to do so. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The elements of aggravated battery are: 1. Michael D. Shaver actually and intentionally touched or struck Laurie Shaver against her will, or intentionally cause bodily harm to Laurie Shaver. 2. Michael D. Shaver, in committing the battery, intentionally caused great bodily harm, permanent disability, or permanent disfigurement to Laurie Shaver, or used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. I believe there's a typo there as well. Great bodily harm, and after great bodily harm, there is another one as well. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include bruises. If Laurie Shaver was not committing any crime other than alleged murder in the second degree, or any lesser included crimes for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had the right to be, then the defendant had no duty to retreat before using or threatening to use deadly force, or before Isabel Shaver used or threatened to use deadly force. If Laurie Shaver or Isabel Shaver was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The use of deadly force is justifiable if Laurie Shaver or Isabel Shaver reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting any attempt to murder her or another, or commit an attempted first-degree murder or aggravated battery upon her or another, or to commit an attempted first-degree murder or aggravated battery upon or in any dwelling house in which she or another was present. In deciding whether Laurie Shaver or Isabel Shaver was justified in the use or threatened use of deadly force, you must consider the circumstances by which she was surrounded at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant or Isabel Shaver actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. Laurie Shaver or Isabel Shaver is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using or threatening to use defensive force that was intended or likely to cause death or great bodily harm to another if A, the person against whom the defensive force was used or threatened to be used was in the process of unlawfully and forcefully entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, Laurie Shaver or Isabel Shaver knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used or threatened to be used has the right to be in or is a lawful resident of the dwelling, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or B, the person or persons sought to be removed is a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used or threatened to be used, or C, the person who uses or threatens to use defensive force is engaged in a criminal activity or is using the dwelling to further a criminal activity, or a person who unlawfully and by force enters or attempts to enter another's dwelling, presumed to be doing so with the intent to commit an unlawful act involving force or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporarily or permanently or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides, either temporarily or permanently, or is visiting as an invited guest. If you find that Laurie Shaver or Isabel Shaver, who because of threats or prior difficulties with Michael D. Shaver had reasonable grounds to believe that she or another was in danger of death or great bodily harm at the hands of Michael D. Shaver, you may consider this fact in determining whether the actions of Laurie Shaver or Isabel Shaver were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Laurie Shaver or Isabel Shaver knew that Michael D. Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver or Isabel Shaver reasonably believed it was necessary for her to use or threatened to use deadly force. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Laurie Shaver, Isabel Shaver, and Michael D. Shaver. Defendant's failure to report a crime. The state has charged Laurie Shaver with the murder of Michael Shaver. Further, the state has charged Laurie Shaver with being an accessory after the fact. You must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. All right, it's about 11:30 right now. I think at this time we'll take our lunch break. Parties have anything further? State? Yeah, come on up, please. Instructions that I will read to you prior to breaking for lunch. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whether the words reasonable doubt are used, you must consider, whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 7, has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? 8, does the witness have a general reputation for dishonesty or truthfulness? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or part of an expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1, whether when the defendant made the statement she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, and was that to the satisfaction of the parties?
Yes, Judge.
Okay. And at this time, is there anything further before we break for lunch?
Nothing from the defense, Judge.
No, sir.
Thank you. All right, we're going to break for lunch at this time. Again, please do not discuss the case with anyone, including each other. I would ask the parties to return to the jury assembly room at 12:45. So that'll give you over an hour for lunch. Thank you. All right, the jurors have exited the courtroom. Is there anything further before you break for lunch? We'll meet back at 1 o'clock.
Not at this time.
All right, then we'll begin closings at that time. Mr. Wiggs, anything further? All right, thank you. We're in recess. back on the record in case number 2020 CF 2361. Are there any preliminary matters, or can we call the jury?
Your Honor, I just have a corrected copy of the verdict form for you. I've given it to.
Yes, sir. Please approach.
I made the typo changes as well as replacing in our packet.
Thank you, sir.
Mr. Wicks.
Appreciate that.
We reviewed them, Judge, have no objection to them.
All right. Anything further?
Yes, sir.
All right, then we'll call in the jury.
All rise. You may be seated.
All right, thank you. Thank you again. I see that all of the members of the jury have returned, and thank you again for your time and attention today. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument, after the defense has given its closing argument. State, you may proceed.
May it please the court.
Yes, sir.
On November 7th, 2015, Michael Shaver went with his family to meet up with some friends at a tractor show. This is the last time Michael Shaver is ever seen by anyone other than the woman that murdered him, Laurie Shaver. You've heard a lot of testimony and evidence over this last week discussing Facebook, phone records, bank records, all sorts of evidence for your consideration. But it's important to remember that why we are here is because Michael Shaver was shot in the back of his head without any sort of legal excuse or justification and buried in his backyard. Michael Shaver, between November 7th and November 10th, shot in the back of the head and dumped, wrapped in a tarp, in his backyard. That's what we've been here this week. That is what the evidence has shown you, and it has shown that the person who did that is Laurie Shaver. The elements of second-degree murder are fairly simple, and it is these elements that the state must prove beyond a reasonable doubt. You can have doubt in this case, you can have doubt in any criminal case. The state's burden is to prove this case beyond a reasonable doubt. These three elements. And that is what we must prove to you. First, Michael Shaver is dead. 2, the death was caused by the criminal act of Laurie Shaver. 3, there was an unlawful killing of Michael Shaver by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. That third element is further defined by the court as an action that is reasonably likely to kill. A gun to the back of the head is obviously something reasonably likely to kill. Done with ill will, hatred, and spite. I can think of no other reason in a
person's mind when they're shooting someone in the back of the head other than those three things. And 3, indicates an indifference to human life. The evidence that you have heard throughout this trial clearly show that that first element and the third element are really just not in dispute. What we are going to spend the majority of time talking about this afternoon is whether or not the death was caused by a criminal act of Laurie Shaver. And the evidence that you have heard shows that the state has met its burden for that element. As you heard the judge give you the instructions already, there is something that is called a lesser included offense to this second-degree murder, and that is manslaughter. The difference between manslaughter and the second-degree murder is it does not have that third element about an act done imminently dangerous, demonstrating a depraved mind without regard for human life. So if you feel that the state has proven that Laurie Shaver is in fact the one that shot but didn't have that state of mind at the time she shot him in the back of the head, manslaughter would be the offense that the state has proven in this case. As we go through the evidence, I want to remind you of something that Mr. Wiggs said in his opening statement. And what said in opening statement is not evidence. If you've heard some things in opening statement that was going to be presented to you when it came out differently, what you heard from that stand, what you got from the evidence sitting on that table over there, that's what you are to consider, not what the attorneys talked about in opening. But what Mr. Wiggs said is you aren't going to hear just find her guilty because common sense. But the instructions that the judge gives you, and the judge will give you a full written packet of all of these instructions, so you don't have to worry about writing down the various instructions as we're talking about them. The judge will give that to you. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. So common sense is absolutely part of the instructions the judge is giving you, and absolutely part of what you should use when you are weighing the credibility of the evidence, the witnesses that have testified from both sides. The state has proven this case through the totality of the circumstances of this entire investigation. It is important to remember that Laurie Shaver is the only one that stood any sort of benefit to gain by the death of her husband. She had the means, the motive, and the opportunity to do this. And when I talk about the means, the gun that was recovered from Robert Seha that he purchased from Laurie Shaver prior to the body being discovered is the same caliber and class as the projectile found in Michael Shaver's skull. And remember the testimony of Megan Cleek, the firearms investigator from the Florida Department of Law Enforcement that did that analysis. Once again, I'm going to trust that you remember what she said as opposed to what the attorneys say about it. But what she said was the projectile that was found in the skull was the same caliber, meaning that it was the right size ammunition to be fired from that pink and black .38 Special. She also said that it had all of the class characteristics from that type of firearm. The only thing she said it was missing in order to make a full comparison and the thing that she would need in order to say, in fact, it was that gun, is it didn't have enough evidence of the individual characteristics from that firearm. You saw the condition of that projectile, how smushed it got once it struck the inside of the skull. You also heard her say, when she did the test fires with that weapon, in the most pristine situation she possibly could, firing into that water tank, the individual characteristics, that were left on those pristine projectiles were very hard to see. So between the time frame, the degradation, and the fact that this gun does not leave strong individual characteristics, it's completely understandable why 4 years later, when it's examined, they just can't find it. But all of the evidence that is in that projectile is consistent with being fired from that weapon. Motive. We actually heard evidence of a couple different motives, because it is clear that she wanted to be with Jeremy Townsend. We are going to talk much more at length about the Facebook activity, the flowers, the messages sent to Vanessa Townsend, but she wanted out and she wanted to be with her new boyfriend. But you also heard her say, when Frank Merritt came to check on the whereabouts of Michael Shaver, when she claimed that he, in the middle of the night, got into a black SUV, abandoned all of his property, his vehicle, his clothes, anything that had any sort of value, and hauled up to Georgia, that she and Michael had had a fight because she found the fact that his previous girlfriend, Kendall Davidowski's phone number was still in his phone. Motive is not something the state has to prove beyond a reasonable doubt. It is not one of those elements. But we have presented you evidence of what her motives would be in this case. And finally, opportunity. That means, was this person in a position to commit this crime? I believe Detective Dale summarized it best when she said, the body was found buried in the backyard. It's not like he got carjacked and shot on I-Drive. All three of those factors point in the direction of Laurie Shaver. So now let's talk and focus on the totality of circumstances. That goes to all of that on that table, all the things that have been presented to you, showing how she hijacked his Facebook, showing how she impersonated him to his friends and family members through texts, Facebook messages, took all the efforts she possibly could to avoid anyone from starting to look. Now, you have heard various friends and family members talk about how over the course of 2.5, 3 years, they went looking for Michael. It wasn't a scenario where he talked to anybody on a daily basis, weekly basis. There were times that he would go and not visit and things of that. But he always responded. When people would reach out to him, he would respond. He wouldn't leave those messages unanswered. And when they did get any response after November 2015, every single person that talked to you about that said it was obviously different. It was not the way he would respond. Finally, when taking all of the circumstances, all of the evidence, and putting it all together, that's where the state is asking you to rely on your common sense. Because you can take any one piece of this puzzle and you can look at that and you can say, well, I mean, that's not an eyewitness that saw what happened. That's not a piece of DNA. Maybe that's not something that proves in and of itself that Laurie Shaver committed this murder. And we're not saying any one piece of evidence over there does that. We never have. We got up here, Mr. Buxman in opening was straightforward with what you were going to see. He told you there's not going to be a witness that's going to say Laurie Shaver did this, that I saw her do this. He told you what the forensic evidence was going to be. We put that up there so you could see it. But we also gave you the explanation of why, after someone is buried in the ground over multiple years and their body decomposes, the effects that that has on any sort of trace DNA evidence, any sort of trace fingerprint evidence. But we were upfront about that with you. We told you that's how it was going to be. But we are asking you to follow that judge's instruction and use your common sense in looking at all of this together. Because when you look at it all together, the conclusion is crystal clear. Let's start going through the timeline. November 7th, 2015 is the last time Michael Shaver is seen by any friends, family members, co-workers, anyone other than Laurie Shaver. November 9th, 2015, after Frank Merritt had reached out first to Michael the day before, text about a gun cleaning kit, did not get any response. He followed up with that, and Michael says, well, I put air quotes, Michael says to Frank Merritt, have to quit my job to work on my marriage. Submit to you, someone going and becoming unemployed and not earning any money probably isn't the best way to go about working on and contributing to the marriage. But that's the first type of response that people thought was odd. November 10th, 2015 was the first time ever that Michael Shaver did not show to work and did not call to say he was not coming in. This continues to November 12th, 2015, and ultimately leads to his termination. November 11th, from those Facebook records, the Laurie Shaver Facebook records, Laurie Shaver posts a public posting to the entire world wishing various veterans a happy Veterans Day. Most importantly, in that list of people that she thanks is her brave, loving man. Michael Shaver was never in the military. Her husband was never in the military. Jeremy Townsend was. One day after Michael Shaver has no contact with his place of employment, she is publicly posting for all the world to see, talking about her brave, loving man, veteran, Jeremy Townsend. November 12th, 2015, John Borglum receives a text message from Mike's phone that's saying he has issues at home and was in Georgia, so go ahead and fire him. Now remember, there's absolutely no evidence whatsoever that he was ever in Georgia. None of his bank records show any activity up there. His family members in Georgia, they haven't seen him. And Mike just leaves his job, his vehicle, everything behind. November 13th, 2015, because this is all extremely unusual, Frank Merritt goes to the Shaver residence to check in on Mike and is told he went to Georgia. Now, when Laurie testified yesterday, she tried to say, oh no, he must have misunderstood. I never said Georgia. Definitely. That's just a misunderstanding. But remember, he's not the only one to say he got a message about Mike going to Georgia. Because John Borglum the day before, in that text message sent from Michael Shaver's phone, and whoever had that said he went to Georgia. Laurie's version of what happened in November. She kicks Michael Shaver out after the November 7th, 2015 tractor show, and he returns to live at the airplane hangar. So now the story has changed from he went in a black SUV, went out in the middle of the night to go up to Georgia, to he is living at the airplane hangar. If that is true, you need to believe all of the following. 1, despite the fact that the last time he was out of the home and living at the hangar, he was still working at Disney, he somehow decides to abandon his source of income. He's kicked out of the home. He's obviously going to need a place to stay. He's going to have to pay for bills, pay for food. But that's the period of time he decides, I'm not coming to work anymore. You also have to believe that he decided to just abandon his vehicle, his source of transportation, his source of actually maybe finding another job, being able to go various places. You also have to believe that he leaves behind anything he has that has any sort of value. Guns, tools at Disney, anything. Now he's unemployed, homeless, gonna need to fend for himself, but he just leaves all of that behind. And then you heard also today from Katina that he left all of his belongings, toiletries, and clothing behind at the house. So you basically have to believe, if you believe Laurie Shaver's version as she told you yesterday, all of those things would have to be true. So what's the evidence that that's not true? Well, the person that she indicated took him to Georgia came in and said, nope, I didn't do that. All of his family members that live in Georgia, no, we never saw him. All of the bank activity is here in Claremont by the home that he lived in with Laurie. The bank activity is not even out by the hangars. There's one entry that deals with Disney, but every ATM withdrawal, Groveland, Claremont, 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 Claremont. He was not in Georgia. No outgoing phone activity after November 7th, 2015. None. And then, if he is kicked out of the home, fending for himself, there is absolutely no reason for him to just also cut off contact with friends, family, and coworkers. But that's exactly what happened. Michael Shaver was dead before November 10th, 2015, because he fell off the face of the earth. There is no bank, phone, any activity that is associated in this day and age with what people need to do in order to survive, because he's dead. These are the various records that you heard about, that you saw. Everything is in those folders so you can review it. But this is what I am talking about the bank activity from the time he was killed, before November 10th, 2015, and then December 30th, when that account just becomes overdrawn and is never used again. November 20th, online purchase to wish.com. November 24th, online purchase to wish.com. 12/14, ATM deposit. What was that deposit? That was the check that was mailed to his home from Mariner Finance. And this is important because this check was sent to the place where she lives. And it was deposited in Claremont. Michael Shaver does not have a vehicle. I think Laurie was trying to explain to you how, well, He would just come by, no one would see him, no one would know anything, but he would just check his mail because it was out by the street. That makes no sense. He has no car, he has no money, no phone, but he's coming by to check his mail and get this check? No. That's just not credible. That's not believable. He then, after he makes this deposit, ATM withdrawal Bailey, 1214, ATM withdrawal Claremont, 1218, ATM withdrawal Claremont, 1221, ATM withdrawal Groveland, 1221, ATM withdrawal Claremont, 1223, purchase from Walmart.com. Who was the purchaser there? She was. You saw the receipts. You saw the Walmart.com records. You saw it went to that address. Finally, 1223, ATM withdrawal Claremont. And at that point, on the 30th, the account becomes overdrawn, never used again. Mike is walking around, having no contact with friends, family members between November and May. We're just getting his money. His bank account is cashed out, absolutely no activity. There's no reason, if he's out trying to forage for himself now, kicked out of the home, living at the hangar, and he doesn't maintain his bank records, bank accounts, but it is depleted by Laurie, because all of that activity is Claremont and Groveland. Phones. This is Michael Shaver's phone records. This is the number that he had. This is the number that you heard his friend Brendan Burns actually pull out his phone, say, I still have his phone number programmed in my phone. This is what it is. This is that 5121 number. And once again, all of these records are in those folders. You can look at them yourself. And obviously, you can't read all the detail here. But the point of putting this up was to show you that this one in blue is that phone call he made out on the 7th to Epcot. That was the Detective Dale told you. That was the last outgoing call from this phone number. In the research, that phone number was associated with a landline in Epcot, where he worked. Before that, this is all the activity. It almost daily calls out, calls in, calls out, calls in. This first area, all those yellow highlighted, are calls back and forth between him and Laurie Shaver. After November 7th, nothing. Not a single call out from his phone. He doesn't have a car. He doesn't have a job. He's not at the hangar. None of his friends there have seen him. He's got to communicate with somebody if he's alive in order to keep going. But there's no activity because he's not alive, because Laurie Shaver killed him before November 10th, 2015. The only phone record after November 7th, 2015 is the collections call from Mariner, because the check that was mailed to her was deposited in Claremont and they were coming to collect. And when they called, remember what Tara Mitchell told you. A female answered the phone and said, oh, this is a new number. But we know that's not true because you have all the phone records showing the history of that phone number, and how it changed. And we'll come back to that. So let's keep going with the timeline. In December of 2015, Mike's mother becomes ill. His family is seeking him out to let him know that she is very sick. I believe the testimony from Stacy Turner was it looked like she might not make it. Couldn't get in touch with him. Couldn't get in touch with him. All the texts, phone, Facebook, whatever they tried, couldn't find him. He's dead. But they did get in touch with Laurie. And she said, I'll get word to him. There's no phone calls to him. She knew she didn't have to call him because she knew he was dead. Because she killed him. March 24th, 2016, Laurie Shaver posts about the fire pit that she made. This is the area that multiple witnesses told you was a hole. It was going to be a duck pond. But now in March 2014, that area is filled in. And wouldn't you know it, Michael Shaver's right there. He's in that. Isabel described it as a really big hole. April 6, 2016. This is where we start showing you how we know Laurie Shaver had Michael Shaver's phone and access to the ability to text people, had access to his Facebook, had access to everything she needed to do to keep people from starting to look for him, to keep people from investigating the fact that she killed her husband and buried him in the backyard. That phone number, 352-431-5121, on April 6, 2016, this would be approximately 4.5 months since Laurie said, I kicked him out. But that phone number gets changed. Saw those records, Vice brought in, changed phone number to 352-801-0941. And then 10 days later, that phone number is changed again to 352-431-8444. As a reminder, the phone numbers that were important in this case started off with the 431-5121 number, the one we just talked about, how it got changed 2 times within the period of 15 days. We know that was Mike's number. The records are connected with Laurie Shaver as the subscriber. We also heard Brendan Burns testify. That was the phone number I've had programmed in my phone since the last time I ever talked to my friend. Laurie Shaver's phone is 352-431-0419. We have her phone records. We have the screenshot from the time frame that Vanessa Townsend had reached out to Laurie to discuss the messages that she had received. We've also had the screenshots from the text messages between Jeremy Townsend and Laurie Shaver, and lo and behold, the phone number associated with Laurie Shaver in those text messages is this 431-0419 number. Now, Laurie testified yesterday and doesn't seem to remember any phone numbers that she's ever had, but the records show it, the screenshots show it, the text messages show that was her number at the time. And then there's a folder that, as opposed to the call details and said this is the call out, this is the call in, that third folder we talked about with Tanner Gale shows the history of that phone number and device. And it shows how on April 6th, the phone number was changed from Mike's original number to the 0941 number. Why is that important? Well, 2 days later, after changing Michael Shaver's phone number to a new number, she reaches out through Facebook to contact Vanessa Townsend and says, here is my number, call me. Vanessa Townsend goes to call that number at one point. Remember what she said. I called this person and asked me to call them. They wouldn't answer, but they would text. Laurie can't answer the phone and pretend she's Mike anymore. She has to text. Well, that number only stays in place for 10 days. She got it. She did what she needed with it. She got rid of that number, got a new number. What number was that? 352-431-8444. Why is that important? Well, in July, she's filing a court document with her address and her phone number, 352-431-8444. This shows that she had the original Mike Shaver phone and phone number this entire time. This shows the constant link between when she killed him in November, had his device, had the number changed to contact Vanessa, and then had it changed again to the number that she represented as hers. April 6, 2016. Laurie Shaver's bank records reflect the purchase of flowers sent to Vanessa Townsend. April 9th, Michael Shaver's Facebook sends Vanessa Townsend, that's when she asks him to contact her at the 0941, the burner phone. And April 11th, 2016, Michael Shaver Facebook sends a message informing Vanessa she's about to get a special delivery. And she does. The flowers purchased by Laurie Shaver, as shown in her bank records. She receives the flowers, exposing the affair. But that's not all she ultimately gets from Laurie via the Mike Shaver's Facebook. She gets pictures after picture after picture, text message, screenshot after screenshot after screenshot. I ask you once again to use your common sense. This is Mike Shaver reaching out to inform some other person that their husband was being involved in an affair. Wouldn't this be enough? Wouldn't this picture do it? Why all that? Why? This was Mike. Would all that be necessary? This isn't sent by a husband trying to inform some other person's wife that their partners were having an affair. This is sent by Laurie Shaver because she wanted to drive a wedge because Vanessa would not leave. Jeremy would not leave Vanessa, and that is what she wanted. September 12th through the 14th of 2016, the cement slab is poured over Michael Shaver's body. That is shown to you by the cement mixer rental thing for that period, and then it is also confirmed in Facebook posts a couple days later at Isabel's birthday party on September 19th, 2016. Michael Shaver's body has been in the ground for some time now, but there is no argument that can be made that after that cement slab is put down, that his body was not there. On September 20th, 2016, after we know for a fact Michael Shaver has to be dead, there is a Facebook message to his niece, and this is the one that reached out to him and said, "Hey Mike, how you doing?" And he says, "I don't know you. I don't know who you are." Because she didn't have the Shaver last name. Laurie didn't recognize her. She's like, "I'm your niece." She talked about how she had discussions with him. Mike knew she was getting married, knew that she was going to be changing her name. And Michael Shaver's Facebook reply is, "I don't have a family anymore. I have no clue who you are. Now stop messaging." September 20th, 2016, after we know Mike has to be underneath that cement slab, he also sends a Facebook message to Vanessa Townsend. "Hi Vanessa, how are you? Moving good looks good on you. Hope you and your son are doing well." Now, Mr. Wiggs has talked at length with various witnesses about maybe Jeremy Townsend had this phone. Maybe he was just driving up to the house for months and months and months after this relationship was ending to try to get into the router to have the IP address match Laurie Shaver's IP address, and that he was the one that was doing all this. No reason for Jeremy Townsend to send this message to Vanessa, because it's not true. It's just as unreasonable as the idea of some sort of hacker getting into Michael Shaver's Facebook account to post a stupid meme. It makes no sense because it's not true. Laurie Shaver had access to it. Laurie Shaver had access to the devices. Laurie Shaver had the means and desire to make people not want to come look because she killed them. March 8th, 2017, after we know Michael has been dead for a very long time now, and known that he is underneath that cement slab, the Facebook profile picture has changed to a photo taken by Brendan Burns in 2014 that he says, "I probably texted to him back then." So who would have access to that to put it up on his Facebook profile to try to act like Michael Shaver was still alive? Someone that has his phone. Who had his phone? She did. And those phone records prove it. January 1st, 2018, that is when Michael Shaver's Facebook profile is changed to the random bar picture that Detective Strickland did research into using the reverse Google image to show that had something to do with some sort of Bloody Mary company out in the Midwest, and Michael Shaver's nowhere in that photo. March 14th, 2017 is when the cover photo changed. And that was that odd-looking revolver that I think had 700 bullets in it that Detective Strickland made a joke about that's not a real gun. Well, it's important to remember that the post of that cover photo and almost the 2-year anniversary of Michael Shaver's death, to put a gun after he was shot in the back of the head, shows that Laurie Shaver's Facebook account and Michael Shaver's Facebook account utilized that same IP address, meaning that they have to be in the same location, the devices that are accessing these accounts. It's the same, whether it's Starbucks, whether it's Laurie Shaver's home, it doesn't matter. It is in the same IP, the same location. Both of those accounts are accessed within 1 minute of each other. Has to be someone that has control of both accounts. There's no other reasonable explanation for that. The Facebook IP logs. We spent a lot of time talking about these. This is a summary that Detective Strickland described. And going through this, you can see how there is activity throughout a 2-year period where both of these Facebook accounts are utilizing the same IP address. Once again, we've been upfront with you since the moment we started talking about this case that we are not going to be able to tell you the physical address of that IP address. But it doesn't matter. Wherever it is, you have to be in the same location to access the IP. And when both accounts are constantly utilizing the same IP address, that shows that that is the same location, the same person accessing that. If you were to go through this and go through all 70 some odd pages, you would see there are 13 separate IP addresses that both accounts utilize over the course of that period. And you heard some testimony about how providers like CenturyLink will sometimes roll that, change your personal IP address to your home every month, maybe every 2 months. What you will see is that both devices utilize a particular IP address for about a month, maybe 45 days. And then it changes to another IP address. And then both of those devices share that IP address for that entire time. There's countless instances in there where you might see the Michael Shaver Facebook address, Facebook account access an IP address, and then the next day, Laurie Shaver's Facebook account accesses that same IP address, and it goes back and forth, back and forth. That is a folder full of those examples. But if you were to go through there, you would not only would you find 13 separate IP addresses that they use, you will see activity on Michael Shaver's Facebook account that continues after the cement slab is laid over his body in September of 2016. You will see there are 31 separate days in that 2-year period where they both access the same IP address on the same day. You will see that there are 12 days in there where there is activity between the Laurie Shaver account and the Michael Shaver account within 2 hours of each other. There is one instance, which we talked about with the gun photo on the almost 2-year anniversary of his murder, that is 1 minute and 7 seconds apart. There's another instance on July 15th, 2016, where the activity is within 6 minutes of each other. This is the same person looking at these, using these. This is one example of the type of thing you'll see in this chart. This is from April 2016 on this side, where you can see there are some days, once again, look through this chart, feel free to do so, where on certain days it's actually going back and forth. Both are being accessed throughout the day. November of 2017, towards the end of that chart, this is where you can see the actual data that I've been talking about, showing the 1 minute. And not only have we given you this summary to try to help you with going through all this information, you have the originals right there, and you can go through it yourself. And you can check it and look at all of that. Justifiable and excusable homicide. Justifiable homicide is going to be the self-defense, defense of others that we will talk about shortly. The excusable homicide instruction is given to you. You heard it, read it. I would submit to you that none of these things apply when the killing is committed by accident and misfortune in doing a lawful act. There's absolutely no evidence of any of that. Accident and misfortune and the heat of passion. Heat of passion is coming in and being so overwhelmed by something that a reasonable person would not act any different. Not to be blunt, but you come in and you see your child being attacked, molested, whatever it may be, and you are overcome with this emotion, and no reasonable person would not. That actually doesn't excuse the killing. It just means that you don't have the necessary intent to commit second-degree murder or first-degree murder. It would be a manslaughter. And when the killing is committed by accident and misfortune resulting from sudden combat, if a dangerous weapon is not used. Well, we know someone was shot in the back of the head. That doesn't apply. Excusable homicide has to be given in every homicide, but none of those apply. Before we talk about the defense of others, I want to go through and talk about the tools the judge has given you to aid in your common sense in weighing the credibility and weighing the evidence in this case. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did they have an accurate memory? Were they straightforward in answering the attorney's questions? I'd submit to you that as you go through this, all of these questions that you ask yourself are pretty common sense, that these are the types of things you should use to try to assess a witness's credibility. Defense of others. The testimony that has been presented to you by the defense is that Isabel shot her dad in the back of the head. And then, just so happened, at that exact same moment, that Jeremy Townsend showed up, grabbed the gun, shot him again, and then threatened to kill Isabel and Aiden if anybody said something. They also say, both Laurie Shaver and Isabel Shaver, that Laurie took them to her kids to school, that Aiden had no idea anything that had been going on. Gunshot in the back porch, huge fight. Isabel said Jeremy threatened him and threatened to kill him. But Laurie said Aiden had no idea what was going on. I just needed to get them to school, and it was a short trip over to school. All I wanted to do is get them to school and then get back home. That's what she said. And she says when she got back, Laurie said when Jeremy got back, Jeremy was gone and there was no change in the property. She talked about how close this school was to her. All she did was take the kids to school and drive right back. Yet somehow, Jeremy was able to clean up the entire scene, remove the body, and I guess come back some other day, undetected, and bury it, and no one noticed disturbed ground anywhere? These rules of weighing the evidence and assessing credibility, the judge has told you specifically, since the defendant has testified, you are to use those same questions, those same tools in order to assess her credibility. And when you look at this story, it makes no sense because it's just not true. Now, ultimately, proving this case is the state's burden. We have to prove she was the one that killed him. They don't have to prove to you it was self-defense or defense of others. We have to prove to you it wasn't. And we have, because all of the evidence shows that Michael Shaver was not alive in November, was not alive when this happened, because he's been dead since November of 2015. Somehow, Isabel, who shot her dad in the back of the head and went to school when she was 7 years old, has absolutely no memory of what year or what month this happened in. What grade were you in? I don't remember. I don't know. What month was it? I don't know. I think spring or summer. What year? No clue. And she said she went to school that day and carried on like nothing happened. It's the state's burden to prove this case. But if you are fed a story that is just patently false and fails all common sense scrutiny, ask yourself, why? Why did they come up here and try to feed that to you? Because to cover up the reality that Laurie Shaver killed her husband back in November. And they're trying to give you a story, and they're trying to fit it in to the timeline that has been established over the course of this case. Because also remember, in the very beginning, when Laurie Shaver was arrested, you heard testimony that her attorney said, you need to look into two people. You really need to look at these people. Jeremy Townsend and James Ballou. Okay? Well, if this is the story back when Laurie was arrested in 2020, why bring James Ballou into this? That's not part of their tale. That has nothing to do with it. But that's how the story started. And then as the evidence progressed, that in 2022, Isabel shows up as this potential witness. And despite what Mr. Wiggs told you in the very beginning, that we were offering the truth to the state, and they shut the door on us. They said, we don't want to hear it. They want to talk to her. But you heard from her attorney. What does she tell you? Every time after she became the attorney of this witness, I would see her and say, hey, anytime your client wants to come and talk, I'm here. Does that sound like the state shutting the door on his theory? Or is that just the convenient tale they want to tell? And we went through Laurie's Facebook because it has been 9 years since this happened. The person, Isabel, that you saw testify is a much different person than the little girl she was when she says she shot her dad. These are the pictures of Isabel from back when she says she shot her dad in the back of the head. Went to school, carried on like nothing happened. And then this great, wonderful mother that Isabel described, who is saying that these two were involved in this horribly traumatic incident in 2016. She go get her therapy, counseling. I think maybe she needs to talk to somebody about the fact she shot her dad in the back of her head and was threatened by her mom's boyfriend. No, one time this year, I saw a counselor and talked to somebody. We're fine. It's no big deal. The story makes no sense because it isn't true. But the evidence completely disputes their tale. Dr. Coberly told you that this is a single gunshot to the back of the head. Isabel told you, I shot my dad in the back of the head. He sat there, he started shaking, he started seizing. And then they said Jeremy came up and shot again. There's no damage other than post-mortem rib breakings from after the body was buried in the backyard for years. Also makes absolutely no sense that if someone was coming in to finish someone off, give them a coup de grace shot with a gun, if they want to put another shot in the head, that they would shoot him in some soft, fleshy area so as to not hit any bones. But this injury, Dr. Coberly looked at underneath a microscope, and she says there is no doubt that is one gunshot. She says even when you have a scenario where somebody takes the gun, pulls the trigger, and immediately pulls the trigger again in that exact same spot, there's going to be derivations, there's going to be enough movement that they can see kind of a figure eight type of movement, figure eight type of configuration, to show that there was more than one shot. There's also only one projectile in the skull. Probably didn't even need that explanation of the microscopic examination because there's only one bullet there. But scientifically, we know Michael was shot one time. Going back into those tests, going to those questions. Does the witness have some interest in how this case should be decided? Laurie Shaver, Travis Miller, and Isabel Shaver are the only witnesses in this case that had an interest in how this case should be decided. Isabel Shaver said, I love my mom. I don't want to see anything bad happen to her. I want to keep my family together. And I understand that. But that doesn't mean what she told you is true. Was the witness honest and straightforward in answering the attorney's questions? I want you to think about Travis Filmer and target his discussion of this commitment ceremony on December 31st, 2016. Nobody thought this was a wedding. We didn't represent this as a wedding. Was she wearing a wedding dress? Yeah. Was she walked down the aisle by your grandfather? Yes. Was there someone there conducting the entire ceremony? Yes. Her testimony from other people, well, they absolutely told us it was a wedding. You also saw the Facebook post that Laurie put up announcing their engagement, saying that I'm going to be a filmer. Now, is that in and of itself the big earth-shattering aha moment? No. But if you can't trust them on the little things, how on earth are you going to trust them on the big things? Laurie Shaver, as far as honest and straightforward in answering the attorney's questions, you got to see the way she testified, you got to see her temperament, you got to see all of that. But also, once again, the little things. Was this your phone number? I don't know. That's the types of tools you can use in assessing their credibility. Does the witness testimony agree with other testimony and other evidence in this case? Everything except for Laurie Shaver and Isabel Shaver show you and tell you Michael Shaver has been dead since November of 2015. And if he's dead in November of 2015, he definitely isn't showing up unannounced 6 months later for the first time on their porch. I guess wearing his nothing but his shorts, socks, and underwear, because that's how the body was found in the ground. Is that somebody that just shows up unannounced and starts a fight? Or is that somebody that was at home, sleeping, in that bed, when he was shot in the back of the head? Even Laurie Shaver and Isabel Shaver's testimony conflicts with each other. Isabel Shaver said her father had not been living at home since 2014, since that DV arrest in 2014. Laurie testified actually consistent as far as that living arrangement as other witnesses that you've heard from, where she says, no, he was living there. But Isabel, now, Dad hadn't been there since September of 2014. Also, Isabel says, Jeremy said he was going to kill me and my brother. Laurie says, Jeremy said, if you tell anyone, DCF will come and take you away from the family. Their stories don't even match. Because it's fabricated. It's made up. It's flat out not true. And it's inconsistent with everything else that you have heard. The only witness that Laurie got up there and say wasn't fabricating something was her daughter. Scott Amatuccio. He's lying that he's actually friends with Mike. They weren't really friends. You heard from Katina. She's like, oh no, they were great friends. Frank Merritt. He's lying. I never told him Mike went to Georgia. Jeremy Townsend. All sorts of lies. He would spend the night. He would be that right there is should be a huge red flag to you. If Jeremy Townsend was out spending the night at someone else's home 3-4 times a week, the way Laurie and Isabel tried to tell you, Vanessa would know. She wouldn't need someone to send her flowers with a card to expose an affair. Vanessa had no clue that anything was going on because Jeremy would go over in the middle of the day the way he told you. Robert Mercado is not being truthful when he said that Laurie got upset one day and was threatening people with a gun. Austin Filmer is not telling the truth when he said that he went over there and helped Travis lay down this concrete slab. Vanessa Townsend obviously is lying because she said there was never any time that Jeremy was missing at night. He always came home. He was always living at home. John Borglum apparently is lying about the reason why he terminated Mike Shaver, because Laurie got up there and said no, he was fired because of a sexual harassment claim. So also, I guess, Disney's lying when they sent over all of Mike Shaver's work records and just hid any sort of sexual harassment claim against him. But today you actually heard the truth about that sexual harassment claim, and nothing to do with Michael. She called it in against Kendall Davidowski, the woman that Mike Shaver was dating when they were separate. Kendall got up there and said, yeah, I worked at Disney. Laurie Shaver called in and made a complaint about the relationship I had with Mike Shaver. So everyone is lying about Laurie, but Laurie is the only witness that you heard from that actually admits lying to other people. She admits lying to law enforcement. She admits that when they came and said, do you know what happened to your husband? She said, I don't know. That was a lie. She knows he was dead. She tries to say, I had no idea he was buried on the property. No idea that he was under this cement slab she poured. But as far as anything that happened to him, no clue. She admits lying to Rabin, her former boss, about the fact that after Michael Shaver was dead in November, she told her former boss, oh, he's in jail somewhere for failing to pay child support and his driver's license suspended. She admits that was a lie. She lies to her son, Aiden, because she says, after I saw Mike killed in the fashion they try to say it happened, she told her son that her dad went away and went to jail. Even if you're trying to cover this up and trying to tell something to the son, why say your father went to jail? That's spite. That's absolute spite on this man that she killed. And then Katina Vasquez, who testified here today, that this whole thing you heard about in 2014, about how this is just so indicative of what happens in the household and how she was abused by Michael and all of these things. What did Katina tell you? Laurie told me that was a lie. Mike should have never been arrested for that. I was the aggressor. I threw the vase. I broke the slide glass doors. I hit him with the gun. Mike can't get up here and speak for himself and defend himself, but he doesn't have to. Because people like Katina come up and tell you the truth about Laurie's lives. Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? Tammy Dale talking to Isabel. Do you know what happened to him, your dad? Isabel, I have no clue. I don't know, he just left. At the CAC, so you did not see anything that happened that would have made you have an idea of what happened to him? Isabel, No. The last time she remembered seeing him,
Is there an objection, sir? Yeah. Sidebar, please.
statements, just remember what Isabel was testifying about. I asked her, did you tell this to Tammy Dale? Did you tell this to CC? She admitted, I told these inconsistencies that are completely different from what she testified. Now, I will also submit to you that back when Laurie Shaver was first arrested is when these statements were made. And this, I don't know, he just left, is consistent with what Laurie Shaver told every other person that came looking. In 2020, I believe the evidence is completely clear that Isabel had no idea what happened. The only thing she knew is what her mom told her, and that's that he just left. And that this story was fabricated. Travis Filmer states in depo that the reason Laurie did not want a legal wedding was due to financial issues. Yet at trial, he said she didn't want a legal wedding because, quote, she did not want to sign a contract with another man. And he started talking about, oh, poor Laurie and the things that had happened to her. But when he was actually presented with that depo transcript and given an opportunity to show me where he had said any of that before, he couldn't, because he didn't say it because it wasn't true. And also, this whole thing about not wanting to sign a contract with another man, we know that's not true because they ultimately got married once they legally could. Once it was discovered that her ex-husband was in fact dead, they got married, and you heard testimony about that. So all of that, not true, completely inconsistent. Travis Filmer states to Robert Prober and law enforcement, but Laurie said it's not that the victim is missing, it's that he is no longer walking this earth. And he just flat out denied it. But his friend, mentor, Robert Prober, and his twin brother, who said he overheard that comment to law enforcement, came in to verify it did. Then Travis Filmer had told his brother, Austin, that there were times that Laurie would get his phone, send texts to Austin, basically posing as Travis. I asked him, had you ever said that before? He said, no, that's never happened, no. Austin, his twin brother, came in and said that absolutely has happened. He's absolutely talking to me. And I could tell because we're twins. The way we communicate was completely different from the way she was communicating with me there. Which is the same thing you've heard from every friend and family member that received texts and Facebook messages from Laurie Shaver, posing as Michael Shaver, since his death in November. Brings us to count 2, the accessory after the fact. The judge has read you the law on this. I'm actually going to hold off in talking about this charge a little bit until after Mr. Wiggs has talked to you. I will tell you that a person cannot be guilty of the murder and as an accessory after the fact to that murder. Accessory means they were helping another person. The evidence we have presented to you proves beyond a reasonable doubt that Laurie Shaver committed second-degree murder. And because of that, the verdict should be guilty of murder in the second degree using a firearm and not guilty of accessory after the fact, because you can't be guilty of both. But the law does allow the state to present these alternate theories depending on how the jury perceives the evidence to make that final conclusion. But I will tell you that the evidence that has been presented is not that in May of 2016, Jeremy Townsend shot this man in the back of the head and Laurie had efforts to help cover that up. It's that Laurie killed him in November of 2015 and she, in order to prevent investigation into her own crimes, covered that up. The evidence of the cover-up is still showing you evidence that she is in fact the murderer. Comes back to that common sense. We've been talking all week about a lot of different things and a lot of different evidence, and what I've been trying to do here is put it together in such a way to kind of condense and show you how the bank records and the Facebook records all fit together. It's up to you to decide what's reliable, and you should use your common sense in deciding that. The totality of the circumstances show you that everything points to Laurie Shaver. She had the motive, the means, the opportunity. Mike is buried in her backyard. She's the one that installs the fire pit and puts the cement slab over his body. She lied to friends, family, and law enforcement about his whereabouts for years. There was no attempts to call Michael after 2015. She depleted his bank account. She sold his property. She posed as Michael through Facebook and his phone. Everything points to her. All the evidence points to her because she is guilty of murder in the second degree. The verdict form that you are going to be presented is not as simple as just guilty or not guilty. We talked about manslaughter being a lesser included, so that is on here as well. The judge will instruct you that you are to find the defendant guilty of the highest level offense that has been proven beyond a reasonable doubt. So I would submit to you as you start your deliberations to start with the murder and go through those elements. Because if the murder is proven, manslaughter is obviously included, so that's proven as well. And you don't have to go to manslaughter if you all agree that the murder has been proven beyond a reasonable doubt. But there's also a couple questions here for you that you will also have to decide that deal with the use of a firearm. And that is crystal clear. There's a bullet in his head, a bullet hole in the back of his skull, but the law requires that you actually designate, yes, she was in actual possession, meaning that she had it in her hand when she shot Michael Shaver in the back of the head. She discharged the firearm and it caused great bodily harm or death. The state has presented to you evidence beyond a reasonable doubt that this was not self-defense. It was not defense of others, but it was murder in the second degree. And therefore, the verdict consistent with the law and the evidence is that she's guilty of second-degree murder, and that all three of those questions should be answered yes. Mr. Wiggs will be up here and talk about what he believes the evidence has shown to you, and I'll just remind you what the judge said, what the lawyers say is not evidence. You're to rely on your own memory of that evidence and what things were presented. So if either myself or Mr. Wiggs are saying something and you're like, that's not what I remember, you go back to your notes and you look and you make sure what you're being told is valid. It's actually what was presented to you today, this week. Thank you.
All right, thank you, Mr. Canuccio. Mr. Wiggs?
Yes, sir. May it please the court.
Yes, sir.
It's been a long week, hasn't it, everybody? And I appreciate y'all being here. I appreciate your attention. I know it was an arduous event. All of us sitting here listening through that, all of the breaks at the bench, all those interruptions, it can be very annoying. It can take a lot of time. It's very distracting, but those things have to happen. In the voir dire, you'll remember, I stressed to y'all extensively about the Constitution. This is something we don't take for granted in a criminal case. Some people may want to downplay it. Some people may want to compromise our rights, the responsibilities, and the privileges that we have. They can't be. They cannot be compromised in the slightest event. This is a privilege we have. It's a constitution that is endured. It was created by hardship for men and women like us to live under the system we have. This system goes, we'll never have it back. We will never get it back. And it is at jeopardy at this stage. I told you that the founding fathers in this Constitution, they recognized that liberty comes with an extreme price. To deprive somebody of liberty comes with a lot of responsibility. Not coming in here, throwing a bunch of mud on the wall and saying, yeah, there you go. There you go. Oh, she lied about this, or here's another misstatement, or here's another misstatement. Laurie Shaver is not on trial for lying. Laurie Shaver is not on trial for bank fraud. Think about that. That the state has the audacity to come in here and state, money's moved, thus she committed a murder. Guns were sold, thus she committed a murder. There's a car in the yard and a misrepresentation, somebody went somewhere, thus causation. That's a huge leap, an extreme leap. Remember we spoke about in voir dire, and I kind of used an example, and I said, I had seen on TV about, and I believe it was Joe Rogan and Jordan Peterson talking about, I think it was Rogan talking about, and he said, I see photos and stuff and talk about UFOs. And he said, and I hear this, and I hear this, and I hear this. He goes, I really would like to believe in UFOs. And he says, but, there's just not enough to put it all together for me. And Jordan Peterson said, yeah, that's a conspiracy theory. What does the state put together here this week? A conspiracy theory. She lied about this. Here's a misstatement. Here's a misstatement here. Here's a misstatement there. She must have murdered the guy. Think about that. Think about the draw and the stretch that the state has put out. Well, she had a motive. All right. That's a big stretch. Okay? I want to talk about the law foremost. And then we'll go over to some facts. And I'm going to show you, undisputably, irrefutably, how more than one reasonable doubt exists in this case. And we know what your responsibility is. And I just ask that everybody abide by it. In the instructions, it talks about, yes, what are the elements of of a homicide. When the killing, okay, excusable homicide, now we're talking about. When the killing's committed by accident or misfortune, okay, was Michael part of his own misfortune? Obviously. 2, when the killing occurs by accident, misfortune, or in the heat of passion, okay, Michael brings on his own death. Michael comes to the house when the state never established his right to be there. We know there were injunctions in place periodically. 3, when the killing is committed by accident or misfortune resulting from a sudden combat. All right. The state wants you to believe Laurie lied about this, or there's a misstatement here, or she's sleeping around. Why did we have to hear that testimony to disparage my client? To think they're going to get emotional impact out of you? Is that relevant to this cause? Is it probative to a material fact that you have to decide? No. It's disparagement for the attempt to pull an emotional result out of you to fill in a verdict form. I told y'all at the beginning in my board item, the state has a responsibility to seek justice. And I said, what is the state seeking here? They're seeking a verdict. That's what it is. So most of what you heard, if not all of what you heard, is an emotional ploy for you to go back there and out of anger for Laurie Shaver, fill in a verdict form for the state. That's what's going on. That's what you've heard this week. Second-degree murder. Mr. Camuccio went over the elements, so I'll briefly touch on it again. The defendant's dead. Yeah, we know he's dead. Okay? The death was caused by the criminal act of Laurie Lee Shaver. Okay. Has any single witness taken the stand and shown you one piece of evidence that established Laurie Lee Shaver killed Michael Shaver? 0. 0. Case over. Period. What they've done is brought in a bunch of digital data after the fact, after the event, and said, well, she tried to cover it up, or she didn't want to talk to this person, or she didn't want to talk to that person. Well, there's a good reason she probably didn't want to talk to numerous of these people, but a lot of it probably didn't have a darn thing to deal with the death of Michael Shaver. 3, there was an unlawful killing, an act eminently dangerous to another, demonstrating a depraved mind, without regard for human life. Okay. Has anybody established a depraved mind? No. Without regard for human life? No. Laurie Shaver was in her house when she was attacked. That's what happened. Did the state offer any evidence on causation, where this event occurred, how it occurred, any different than what the defendant and her daughter testified to? No. No. In fact, you may remember Tamara Dale. She gets up there, and I talked to her about it. And I said, you don't have any DNA, do you? No. You don't have any prints, do you? No. You have nothing in the scene in the house to suggest any activity, do you? No. You don't have anything in a gravesite, do you? No. You don't have any prints in there? No. You don't have any DNA in there, do you? No. You don't have any gun that links Laurie Shaver to the crime, do you? No. You don't have any confession, do you? No. You don't have any witness, do you? No. She admitted all that. And then her response was, well, how could we solve a murder any other way if we had to have all that stuff? Because you normally have that stuff if a murder has occurred and it's attributable to one person. The state tried to compromise that obligation. Do you remember? Do you remember how? They said, hey, Mr. Camuccio said, you're not going to hold us to that standard like CIS that you see on TV, right? Trying to lower what you could expect to see in this case. You're right, he said that, because he knew he didn't have any evidence. So we wanted to mentally prepare you to get you ready to not see evidence. That's what that was all about. You remember his statement earlier as well? We talked about the burden of proof. You'll remember that. And I talked about it in voir dire, and I talked about it, and I said, it's kind of like a football field. I said, in a criminal case,
Here, I'm going to object.
this is an analogy for closing.
Let's have a sidebar, please. Thank you.
Football field. And I said, look, if it was a civil case and the standard is beyond reason, is by a preponderance of the evidence in a civil case, that's just tilting the scale, getting past kind of the center of the field. But in a criminal case where our founding fathers put the premium on liberty and the obligation on the state, I said it's the highest standard required under the law. You got to be on the end of the field, down here. There's a high difference between this, which can't be downplayed in this case by the state throwing some mud on the wall and saying, oh, there was a lie here or there was a lie there. You see? The state can't compromise that. Go on a little bit. When we talk about depraved mind, and you hear that word, and you'll have a complete set of these instructions. You go through them at your leisure, need be. Okay, it says, an issue in the case is whether Laurie Shaver did not have a depraved mind, without regard for human life, because she acted in the heat of passion. Okay, inadequate provocation. In order to find that the defendant did not have a depraved mind, then it gives you some factors to consider. There must have been a sudden event that would suspend the judgment. B, a reasonable person would have lost normal control. Driven by blind or unreasonable fury, there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act. Y'all saw these photos. Y'all know there were repeated acts of violence in that house.
This was not a blind event that Laurie Shaver just stepped up for her child and said, I'm not going to act. They knew what was coming. And this is evidence that they knew what was coming. We had multiple injunctions that were filed with the court. Michael Shaver had been prosecuted in the past, and the state wants to sit here and say, hey, this was some blind event and she just murdered her husband. I'd like to hear an explanation for that. Let's move on some. Let's talk, because the state's going to have the last word in this case. They always do. We don't have the privilege to respond to their last word. Okay? Let's think about this. She's charged with accessory after the fact as well as a crime. What are the elements of this offense? And let's think about it. They state that a murder in the second degree was committed by another. State has a real courage to announce who that another person is in the elements or in the information. They don't have the backbone to tell you here who the actor is, who the principal is. And yet they'll come into court and say Laurie did it. Then it says, after the murder, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid another person. Stop. Right there. We see and hear talk about money going into the bank or going there. Okay? Is there been any showing in this trial how any money was moved to assist, aid, or attempt to aid somebody in escaping detection of a crime? No. Laurie's using money to live a life, feed her kids, that the state can't not deny is marital money, equitable money, that she didn't have a right to touch it, anything like that. But it's all a pull for you. And then it says, and at that time, Laurie Lee Shaver knew that the other person had committed murder. Okay, let's think about that. That's an important element as well. And I'll tell you why. If you have a right to self-defense, no crime has been committed if somebody dies. No crime occurred. So you'll have to assess, was there a right of self-defense? If so, no crime has occurred. 2, where was money being spent to aid detection for somebody who had not committed a crime? You see? Does that make sense to you? Under the justifiable use of self-defense, it represents, and I'll just highlight some of this for you because I want to talk about facts. It says Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel was justified in using or threatening to use it, if she reasonably believed. Now we know the history in this family. That's undisputable. That's physical. That's not to be questioned. Was necessary to prevent imminent death or great bodily harm to herself. Okay? And then it goes on and tells you, well, what's the type of harm that they suspected would happen? Michael's trying to kill her, or he's trying to commit an aggravated battery. And then the instructions tell you what that is, what the elements of first-degree murder are that Michael's trying to do,
or how he's trying to create another hard battery on her. Okay? And that's spelled out in these instructions. Then the instruction will tell you as well that justifiable use of force is justifiable if Laurie or Isabel reasonably believe that the force was necessary to prevent imminent death, meaning that a murder, attempted murder on her, or great bodily harm. Has the state eliminated this defense? No, not at all. They want to throw mud on the wall and say, well, she lied here. She spent some money here. But they can't say first and foremost she didn't have a right to defend herself, to establish that a crime even occurred. It's actually, listening to this case, I got to tell you, I'm spun around listening to it. The judge is going to give you an instruction because they've made an issue in this case out of this. And it's an important instruction because it kind of strikes a nerve in all of us. And it says this: you must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. Laurie Shaver could watch Jay Townsend shoot somebody and had no duty to call the police. Isabel would have no duty to call the police if she hadn't shot him or done anything. Okay? That's a fact. That's a law. The state will act otherwise. Like, no, they could have called 911. Why didn't you call 911? Again, we spoke about this in Board 9. Let me grab it. Foremost, I'm going to say, excuse my handwriting. Okay? Probably the worst penmanship in the state of Florida, if anybody. But anyway, the judge will tell you that a reasonable doubt, and they're in your instructions. I briefly spoke about it because this is very important. If there's one reasonable doubt, it is the requirement, the responsibility, the necessity of any and every jury to return a verdict of not guilty. Not guilty. How does it arise? From the evidence. It can arise from the evidence itself. It can arise because of the lack thereof in the evidence. It can arise by a conflict in the evidence. Those instructions tell you. And they further say that if your feeling is not stable, but one that wavers and vacillates, you got a reasonable doubt. You see? Now let's shift over to the facts and talk about some of those facts. One we spoke about, and I want to remind you, the burden of proof is entirely on the state. Ms. Shaver was not required to take the stand, expose herself to criticism, ridicule, or the misstatement here or there. That burden stays on the state. We know, in this case, it became evidently clear, and should be to everybody here, that Ms. Shaver was in a marriage that had gone bad. It was a case where children lived in an environment that, as Isabel said, it just became commonplace to see these things happening. My dad striking, forcefully, acting out on my mom, and she said, I soon developed an attitude of feeling a need to protect my mom. I soon just responded with a attitude of response trying to protect my mom. That's how bad it got. So she said on the day that this happened, she goes, she was kind of in shock, went to school, and just kind of tried to put it out of her mind. And that's what happened. And yet the state, despite all this, wants to criticize that girl who's a victim in this case. Shame on them. This little girl is a victim of a house with continual domestic violence, and the state says, well, why didn't she get counseling? Why didn't she get counseling more? The state chose to ignore this girl. She was brought to their attention, as well as Mr. Ballou. Mr. Ballou had prior tensions with Mr. Shaver. That's why his name was mentioned. Mr. Townsend's name was given to the state. The state took no aggressive action to look into this case. I asked Tamara Dale, state talk to you about this? Did you make any efforts to go see her? Not ask Kelly Johnson, hey, if she wants to come by, why don't you just bring her over? I mean, is that investigation? That's not investigation. That's just saying, bring us some evidence. We'll maybe look at it. State was aware of the domestic violence in the house. They had evidence. They had prosecuted Mr. Shaver for a battery. They knew about it. Wilma Nichols gets up there on the stand and says, yeah, well, Michael's story at an earlier date and time was that his wife attacked him. I said, are you talking about the same incident where he was prosecuted and the state went after him? Well, yeah. Yeah, that had a lot of merit, didn't it? There was nothing contrived by Laurie Shaver and this minor child. Now listen to me. The judge is going to tell you, you had the privilege of believing all, some, or none of the witnesses' testimony. So if you find that there was misrepresentations by Laurie Shaver here or there or one way or another, okay, you can disregard those. You can say, I don't believe that truth. But again, whereas the state led you to believe that Laurie Shaver killed Michael Shaver, they haven't. There's no evidence in that regard. We know there was times when Michael was not residing at the residence. That wasn't contradicted. His former girlfriend gets on the stand and says, yeah, he was living at the hangar here and there. Laurie said, I let him in the house. There were injunctions. He was coming and going. Did the state offer evidence that there was not an injunction or he was not restrained from the house, not permitted into the house on a date specific when any homicide occurred? No. No. Now, let's shift over to, for a moment, to the digital data. That was interesting to me. Kind of interesting, okay? You got some guy at the sheriff's office, corporal, he had to advise me, that does some tech work out of there. We never heard his qualifications, any experience really he had. Okay, I heard a lot of arguments from him. But we heard Connor take the bench, a man that had been involved in I don't know how many trials, federal trials, trials everywhere. And he had testified in court with his special skills. And he spoke to us real clear and simple. And he said, now think about it, he said this, the IP records from Facebook, CenturyLink, etc., at a point in time they expire and don't tell you the physical address it's coming from. They may have IP logs, records, you see, but you don't know where it's coming from. It could be Starbucks, it could be overseas, it could be here or there. So the state, trying to throw some mud on the wall, says, look at these IP logs, look at this, look at this. But you know what? It doesn't tell you where it's coming from, any device, or any user. You see? That's a significant fact. So the state says, well, somebody sent this, and somebody sent this, and this went here, and that went there. That would create a lack of evidence, a conflict in the evidence as well. And it certainly would not create stability in the way in which you think about it. If Jeremy Townsend is sending some of these, he could be at Starbucks, he could be at his house, he could be anywhere. He could be in a driveway, and he certainly had a motive that can't be excluded. Now, this child wants to be the state disparages this child because she doesn't know it's state specific. She said sometime in the spring. She didn't say summertime. Mr. Camuccio went on and he said, now today, well, she said the spring and the summer, and that's not true. Mr. Camuccio's not presenting evidence here today, but some of his statements were not accurate as to the content of the witnesses themselves. You'll have to rely on your memory, the notes you've taken here. Now, there's a discrepancy exactly, precisely, in what Laurie said and what Isabel said. Isabel, I believe, says, and you have to rely on your memory, she made some statement to the extent Jay threatened to kill us or something of that nature. Laurie said he implied it or something to the children. There was a little discrepancy, but they got the message loud and clear, okay? Don't tell anybody or you guys are going to get in trouble and you're going to be harmed. So, one, she doesn't have a duty to report anything, and somebody's threatened her. She's been the victim, we know, of repeated violence. It kind of makes sense this woman doesn't want to come forward with that kind of threat against her. It kind of makes sense that Isabel is not going to school and wanting to tell everybody all about it as well. Now, let's talk about a little bit about this shooting. The state's made issue of this, and I want to bring something to your attention, and I hope you picked up on it in trial. We heard from Dr. Shaw, the medical examiner, and we heard several things I did, and it was brought out through his testimony. One, he said there was a gunshot here to the rear of his skull, and we know that, okay? And I elicited testimony from him when I said there was no soft tissue on this body, correct? Yes. And I said, could it be that somebody shot through some soft tissue and that may account for the presence of the shrapnel? He says, yeah. And so you may have a bullet that goes in, exits an eye, and there's some shrapnel in that skull. I asked him, did anybody do any meteorological testing on the fragment together with the shell to see if they were linked together? No? Now, who's in charge in directing them to do these things? The state. Does that create a lack of evidence? Correct. Does it create a conflict in the evidence? Yes. Does it create stability in your mind? It shouldn't. Okay. Whose obligation is that and the burden rests with to come in here and prove these facts? The state and only the state. Now, one thing further I brought out, through Dr. Shaw, and I know you all probably heard it. I don't know if you picked up on the significance of it at that time. But I asked him about injuries and the nature of the injuries that existed on this body. And I said, were there post-mortem injuries to the body? And he said, yes, there were. And he noted several ribs. And he said those were post-mortem injuries. And I said, when we talk about post-mortem injuries, how do you identify them? And he described about buccal fractures in the ribs and the way to identify it. And he said, this is where the body is broken after the death, and there's a discoloration in the ribs here and there. And I said, could that be accounted for? And he said, that can be accounted for by moving the body. I said, correct. So Jeremy Townsend, logically, tells Laurie Shaver, I'll take care of this. She understands they got property elsewhere, logically. That body disappears at that time. Now, when did the body logically and arguably show up? When, after that shooting, when Laurie said, it's over. It's over. Okay? She even took the stand, and I thought this was kind of sad listening to this. And after all the violence she incurred, she started crying and saying, I still loved Michael. So we know any relationship between these two was logically over. Now, maybe, and I don't know, we talk about flowers being sent, cards being sent. Was that sent by Laurie maybe to make sure Jeremy's not coming back? Maybe to get him in trouble with his wife? Possibly. You may interpret it that way. Now, we also heard from Mr. Cios, remember? And the state called him. It was their witness. And he said, I asked him this, didn't you call Laurie, advise her somebody was trespassing on your property? Yeah, she was gone, and I saw somebody trespassing. Who had any motive to come back to that property, deliver something back to that property, if it had been removed? Jeremy. You see? That fits together a little tighter. Now, talking about that gravesite, did the police think about the depth of the site, the height of Mr. Townsend versus Laurie Shaver? No. Never even analyzed that mentally. It's not that difficult to think about that. Okay? Also, there's a blue tarp in the grave. Right? We heard all about that. And I said this, and I don't know why this wasn't done. We had told the state about Jeremy Townsend. I said, did anybody do a financial audit of anybody's accounts to see who may have purchased a blue tarp? No. They should have. I'm telling you, if they had one on my client, they'd be in here waving it up in the air. It's her tarp. Lack of evidence, conflict in the evidence. I asked the officer as well. I said, did you guys, I said, you didn't find any prints on that tarp, did you? Now, I like the way the state tries to cover some of these lack of evidence up. Okay, I really kind of got entertained by it at a point. They'd say this, well, you weren't surprised, officer, that given the evidence was degraded that you couldn't find that, could you? No. And I'd say this, hey, what do you mean degraded? The evidence may have never been there in the first place. It could have been degraded when it went into the ground, and evidence was put on it prior. How do you know the condition of the item before it went in the ground? But they had to acknowledge that, yeah? So the state would repeatedly, to try to cover up the lack of evidence, well, you're not surprised at this. It was all degraded. You wouldn't expect it to be there, would you? No, no, no. So that's how they try to defend themselves against the lack of evidence. We saw that repeatedly in this trial. Now, we heard with regards to the tarp, the state never investigated it. One, party with the burden of proof. Two, we heard Laurie and Isabel both take the stand. We didn't have one. We didn't have one. Now, that logically goes with the theory that that body had been off the ground, off that site, because it comes back to the property and it ends up in the gravesite. Can we assume that Mr. Townsend put that in there with the straps, wrapped it up, took it off-site, damaged the body, brings it back and puts it in the grave? That's a logical conclusion. I asked the investigator, I asked the tech people, listen, were there any telltale signs on that tarp that tarp had been dragged across the yard? Huh? What do you mean? I said, did you ask for any kind of chlorophyll testing underneath it to see if it had been dragged by somebody? No. You see? Do you know if Laurie took it out there? I don't know. Do you know the distance from the house? No, we don't. Somebody else can tell you that. So what does the state do? They offer some evidence showing she's working out, and you're just to jump to this conspiracy theory and say she could have dragged it out there? She could have done this? She might have done this? For you to fill in the gaps that the state failed to investigate? And that's what we see in this evidence thrown in your face without a real connection? You look at the forensics. I brought out, state didn't do it, the defense brought it out. There's no DNA in the house, no evidence of how the crime occurred in the house, no prints, no hair analysis, yet there were hairs. Okay? No match of any flooring that was found in the gravesite to implicate Laurie Shaver. Those all create a reasonable doubt. The state can't ignore it. Instead, they just want to say she lied about this or she lied about that and she's sleeping around. That's their case. That's the state's case. Now think about the gun we heard about. We have a gun in evidence. Again, kind of a comical display to me. You get this lady up there, and she goes through this litany as to her experience and everything. And she talks about, well, it has the signs of other guns, meaning this manufacturer that make Colt or Smith & Wesson that may manufacture a .38. They got a machine. It's going to have ridges in it. They all have that common characteristic. Millions of them. Okay? But she can't identify any specific features of the gun. She can't narrow it down from millions to say it's this gun. Wow. Wow. So the state says it can't be excluded? No, it can't be excluded. Right. That's reliable evidence for you to hang your hat on and to fill out a verdict for the state? No. The state's position is, well, we don't have to prove this case by 100%. No, they don't. Okay. That's not their requirement. We know what the requirement is. When Jeremy Townsend, the state was informed of Jeremy Townsend, why, ask yourself, didn't they look into his financial records? Lack of evidence. 2, why didn't they look into his Facebook aside from his banking? Do you remember what the testimony was on that by Tamara Dale? Here's what she said. Well, those records were too old. What do you mean they're too old? You're going to stand in here and tout that Laurie Shavers are reliable at the same period of time and not look into Jeremy Townsend, who you've been advised shot the guy? And not even look? Not even look anywhere into his matters? No. She was closer to the body. Okay. Now, let's talk about the patio. State thinks that's a big deal. I don't. Why? Because they had cleaned it out to make a pond. We all know that. Okay. They get tired of building this pond, and it sits for a while. Concrete is bought. Now let's think about that. Nobody goes and tries to conceal themselves when they're buying any concrete. They don't go paying cash. They don't go in there with a hat on or anything like that trying to disguise themselves. It's open and clear. They're not trying to conceal themselves. They go rent a mixer, not trying to conceal themselves, not trying to make it private, or a hidden event. They even post it on Facebook. Like this is a big secret? No. No. Who would do that if they're trying to hide a fact against the public and knowledge? You wouldn't do it that way. That's just common sense. Okay? You take the evidence and then you rely on your common sense, or the lack of evidence thereof. That's the point. Who would write their name in concrete on top of a grave of somebody that they allegedly murdered? Not any person in the face of this earth would do such a thing. You got to admit that. So you see, there's another reasonable doubt the state can't account for. We had Holcomb, officer, take the stand and said, oh, it was right in the middle. Okay? Like it was obviously trying to be concealed. It wasn't. When I pressed her on the video, she said, well, it wasn't on the middle, actually. Then the next officer said, well, it was a darkened spot. And you look on the photos, well, there's about 3 or 4 darkened spots all over the place. Okay? Doesn't mean, we know there's a body on there. There is clear evidence of guilt or anything like that. I want you to think about all those things that create a reasonable doubt. There's multiple, and the state can't excuse that. They cannot excuse those factors. There's a question, who killed, actually, Mr. Shaver? We know there's shrapnel. We know there's one fragment, but the shrapnel could have been a second shell. We know that from Shaw himself. Has the state eliminated self-defense? No. No, they haven't. Who has that burden exclusively and only? The state. We know this is a violent man who most likely didn't have a right to even be in the house. Is there evidence that the body was moved? Yes, there is. Has the state refuted that? No. Why no forensic audits? None. Now again, the state is looking for a verdict on something. Give me something. Give me something. So they got lessers, a primary, and an accessory. You have to understand, Laurie Shaver is not guilty, she's not guilty. Don't be pulled into an emotional game trying to compromise, thinking you're doing justice one way or another. You have to understand that. Laurie Shaver is not guilty of any crime. She has not committed a crime. The state has not refuted it through an investigation and presentation of evidence in this case. Again, I'll remind you with regard to the crime of accessory. It must first be established that a crime was committed. If there was a right to self-defense, no crime has been committed. You see? And there is anything that Laurie Shaver did was lawful. The state can't link up any transaction unjustified or evidence of a cover-up if there is no crime that is committed. Likewise, the crime of accessory must establish a firm timeline as to when the crime occurred. You're not at liberty to say, well, the state says this and Laurie says this. Let's just pick a number. Could have happened between this date. The court will instruct you that that accessory requires the completion of one event before the start of an accessory offense. Okay? Has the state firmly established that? No. What they do is they say, well, there is, he didn't show up at work, so you gotta assume that she murdered her. And then let's take the next step and say all this stuff was to aid or assist in concealing an offense versus living expenses and money that she had a right to touch and use. An accessory, when you see accessory, normally what you would see is somebody buying somebody a flight ticket to leave town, putting them in private housing, doing things to conceal them in that manner. Not living like this. It kind of reminds me, this case, when I listen to it. It's all speculative, what you call circumstantial evidence. I'm sitting here listening, sitting at my table, between approaching the bench, I guess, and listening to this, and I'm going, it's like playing a game of Jinko. Sooner or later, this thing's got to topple. You can't just keep putting little boards on top of each other without a firm foundation, you see. It's not going to stick. So the state just piles up some evidence and says, there you go. Come back here, reach us a verdict, okay? Give us what we want. Now again, I remind you, and I'll sit down, leave it to you. The people that may have been misrepresented, the people that any lies or misstatements were given to, really are not relevant in this case. Laurie's not on trial for lying. She's on trial for murder. Any misstatement must have been to make and conceal a crime which never has occurred, you see. If she lied about Michael, where he was, or what happened, or where his tools were, or where he'd been, is not really relevant in this matter. So don't be distracted in that regard. Going back to the digital data, I'll leave on this. Remember, I asked these witnesses, did you find anything in the digital data that announced or indicated somebody had shot anybody? No. Did you see any evidence in the digital data of any effort to conceal a crime? No. Could you tell me where this was coming from physically? No. Could you tell me who was using the device? No. So what did we have? I found it, I don't know, I don't want to say it, but we get memes thrown in front of us and some emails from this place to that place, and you're supposed to say, let me hang my hat on this meme. Sometimes you got to burn a bridge and move on. That means Laurie Shaver killed somebody? And that's what the state is asking you to hang your hat on and just pile up a bunch of memes like a Jinko game? No. That's not how you prove a criminal case with suspicion, bare innuendos, without physical evidence of guilt. Now you have, likewise, and I mentioned it to these people on cross, I said, you got a certificate over there, a business record certificate from Facebook, right?
I'm going to check. Approach.
Sidebar, please.
Business record certificates from Facebook. Really interesting. I brought it out on cross-examination. I mean, kind of floored by it. But here's what they say. In essence, read them yourselves. Well, we once had this data. We gave it to you earlier. We're sure we gave you something that was accurate, but we don't have the information anymore. So we got to just assume it was accurate. Okay? That's what the state's going to hang their hat on and say this digital data is even reliable for your consideration? That's not even digital data. And we know what Connor said. You can't even link it up from this place to this place because IP addresses have expired the physical location, and the state's hanging their hat on it to throw all this out there. Unbelievable. Further, the state doesn't even have a computer. There's no computer in this case. Not a computer for them to try to connect it to. I want you to think about these factors. This is where, ladies and gentlemen, my power ends. This is where yours begins under our Constitution. I can only ask, I can only beg you to do your duty. Don't compromise your duty. I've listed to you multiple reasonable doubts in this case. They should never be compromised by any single one of you. I asked each and every one of you as well to please hold your verdict, and if it disagrees with other ones on this verdict, on this full jury, that you please hold your ground. I've shown you everything, every way the state has failed in this cause. Don't be misled, I ask you. The state will have the last word in this case. They always do. Wasn't like that always when I practiced law, but it is now. But as Mr. Camuccio speaks, I ask you to listen. Give him the due concern that you've given me. But I ask you to ask yourself, as he speaks, what would Mr. Wiggs point to refute that? Have you answered Mr. Wiggs's questions? What about this question? What about the grave? What about the lack of evidence? What about the gun? Let's hear an answer to all these things. He can't give you an answer. So I ask that when you go back there, I know the answer, which should be given by you, but I can't do it. But I ask you to do the right thing and come back on all counts, all issues, and do justice. Not seek a verdict for the state. Seek justice, as I've asked. And return a verdict on all counts of not guilty. Thank you.
All right,
Thank you, Judge.
Thank you, Mr. Wiggs. At this time, I'd like to give the jurors a comfort break. We've been in proceedings for nearly 2.5 hours, so let's take a 10-minute comfort break. Thank you.
We stand down, Judge?
Yes, sir. So we're in recess for 10 minutes. Thank you. testify. You may be seated. Wait for Mr. Wiggs and his client to return. Thank you. Are we ready for the jurors?
Yes, sir.
Yes, sir.
Okay. Please bring in the jury. Thank you. You may be seated. I see that all of the members of the jury have returned. State, you may proceed.
You may please record.
Yes, sir.
Counsel.
Yes, sir.
Mr. Wiggs asked who would write their name in concrete over the grave of their dead husband. A woman who killed her husband with ill will, evil intent, hatred, and spite, and then over a period of years covered that up with lies and manipulation against all the people that knew him. That is who writes their initials on top of that grave. And that is what happened in this case. Mr. Wiggs brought up numerous things. I'll try to address as many as possible, as quickly as possible. But some of the things he said, I ask that you go back and think about what's your memory of the evidence and the testimony and realize that that's just not the way it happened. First thing one of the things he brought up was talking about how the state didn't bring you any things about how there was no DNA evidence in this case. I did. Edgar Perez from the Florida Department of Law Enforcement testified about the DNA analysis in this case. Who called him? Mr. Wiggs? Or the state? We presented that to you. We presented you the fact that what the DNA evidence was, and the fact that it's not that it was someone else's DNA and we can't match it up. There's just not enough genetic material in anything that was in that gravesite to compare to anyone. But that came from the state. And Mr. Wiggs got up here and talked to you and said that he was the one that brought that out. And that's not true. It just goes back to the can't trust the little things, how can you trust the big things? He talks about what he refers to as shrapnel in the skull and how that's evidence of potential 2 bullets. That's what Dr. Shaw told you. That's not what Dr. Shaw or Dr. Coverley told you. They said that shrapnel is not evidence of a second bullet, but when there is gunshots like that, typically there will be small metal fragments from the bullet. There's only one entry wound. There's no exit wounds, and there is one projectile. There's no second bullet. There's no second shot. He talks about how the state has presented no evidence to refute self-defense. The state has presented undeniable evidence that Michael Shaver has been dead since November of 2015. And if he is dead in 2015, he can't possibly be on the Shaver porch sometime in May in 2016 and have the events that were relayed to you happen. That's how we've proven to you beyond a reasonable doubt that this wasn't self-defense, because we've proven to you beyond a reasonable doubt that he has been dead since November of 2015. And if he's been dead since November of 2015, Jeremy Townsend had nothing to do with it, because that relationship had just started at that point, continued up until April of 2016 when the affair was exposed, and then it was over. Laurie Shaver can tell you what day she kicked her husband out of the home in November of 2015, but cannot tell you the day he died. Think about that. Isabel can't even tell you what month or what year, but Mr. Wiggs says she's a kid, that's not a big deal. Laurie Shaver cannot tell you the day her husband was killed on her front porch. That is completely unreasonable. And the only reason for that is because she's afraid I'm going to find something in some of these records to completely refute it. So if she tries to keep it vague, that's harder to do. But Michael Shaver has been dead since November, and if he's dead in November, the way Isabel and Laurie described these events to you could not have happened, and therefore it's not self-defense or defense of others. Once again, talking about Isabel and her inability to even remotely tell you when this happened, Mr. Wiggs says that I just completely made up this summer time frame. I asked you to go back, think about her testimony, look at your notes. When I went through and I asked her, can you tell me what grade you were in? No. Can you tell me what year it was? No. Can you tell me if it was around a holiday? No. The best she could do is say that we went to the beach, so it was sometime between spring and summer. And then I asked her, what spring is to you and what summer is to you might be different to me. So what is spring to you? And she said April. I said, what is summer, end of summer? And she said that would be before school, August. That was her testimony. but to rely on your own memory of those issues. Briefly talking about accessory after the fact. And the reason why I say briefly is because the state has presented to you evidence beyond a reasonable doubt that she is in fact the murderer in this case, because her husband was killed in November of 2015. The evidence, the story, with all of its holes that the defense has been presented to you, if you were to believe that and ignore all the evidence and just ignore the facts that Mike was completely disappeared off the face of the earth for 6 months without a car, without a job, without a bank, without a phone, without any contact from friends, family, coworkers for 6 months, and showed up without a vehicle, dressed in shorts and socks, and this event happened in May. The events as described to you by the defense show that she's guilty of accessory after the fact. Even if the initial shot by Isabel was in defense of others, according to them, when Jeremy Townsend comes up and shoots again, coup de grace, puts him out, kills him for sure. That's not self-defense or defense of others anymore, folks. That's murder. And when Laurie lies, manipulates, and covers up the fact that her husband has been dead for years, that's maintaining, assisting, and another person to conceal evidence of this crime. The defense's story is that she's guilty of accessory after the fact. The evidence in this case is that she's guilty of second-degree murder. And as I told you, the law says you can't be an accessory to your own crime. One of the things that I think is very important, one of the details that also undermines their whole disappearing body story, is Laurie's actions when law enforcement comes and excavates the gravesite. First and foremost, their story is somehow in that short drive back and forth to Pine Ridge School, Jeremy somehow got the body out, cleaned it up. They speculate maybe he drove a couple hours to Crystal River to hide the body up at his parents' house for a while, only to return at some other point to bury the body unbeknownst to Laurie Shaver in the backyard. She never notices any, like, oh my gosh, why is there upturned dirt here? And then returns the body, buries it without her knowledge, and of the entire 5-acre plot, she just so happens to choose that to put a cement slab down. That's completely unreasonable. But she needs to say that in order to convince you that she didn't know the body was there. But you have evidence that absolutely refutes that. Because Jessica Wade testified that they were doing this search and this excavation. And Laurie sat in her truck and was sitting there the whole day, the whole time, watching. When did she leave? When law enforcement started to pull up that concrete over the body of her dead husband that she murdered. Law enforcement, when they were done the process, when they were done search, took a couple of days, Detective Strickland called her. He said, Laurie Shaver, we are done all our work. You are allowed to come back to your property. Would you like to know what we took from the property? And she said yes. And he went through and proceeded to tell her everything that they took. We took some swabs, we found some projectiles, we took some other items from inside the house. We took skeletal remains from your backyard. And this woman who is sitting here trying to convince you she had absolutely no idea that her dead husband was buried under the cement slab that she poured or helped pour, had no reaction whatsoever. That's why we played that call. That's why we had that for you to listen to. So you could see just how she reacted when told there was a dead body in her backyard. Nothing. Because she knew it was there. She absolutely knew that. The defense has talked about how law enforcement, how their investigation, and they didn't look into self-defense. They didn't look into this story. And despite the fact that Kelly Johnson sat up there and told you, yes, the state was asking me repeatedly if I was going to produce my client, yet I did not do so until they issued a subpoena to her for deposition, thereby giving her immunity, I wasn't going to allow her to talk to them. But he wants to put the blame for not looking into her on me? When the witness he called said I was the one preventing it because I was doing my job as an attorney, and he sits up here and tells you that's me not looking into it? That's just not true. And it's not true based on the evidence he presented. He also talks about, in this, has the state eliminated self-defense? And it always is going to come back to the evidence shows you that Mike Shaver was dead since November of 2015, and that is overall how the state has proven to you it's not self-defense, defense of others, because that story in May can't happen if he's dead in November. But also think about whether or not their story is even reasonable in this situation. The scenario as outlined by Isabel and Laurie happens. What reasonable person is not calling 911 to let them know? I'm not saying do it in front of Jeremy under this scenario that they've outlined, but go some other place, call 911, explain what happens. The idea that Jeremy comes in, sees Mike Shaver shot, and then in that scenario decides he's going to shoot him again and move this body to different parts of the state and come back, that makes no sense whatsoever, and there's no evidence of it at all. He points to the neighbor, Robert Seha, saying, well, I saw a trespasser one night. Well, fine. Did that person have anything? Were they doing anything? I didn't really see. Do you really even know if they were a trespasser? Not really. But most importantly, he says that happened in 2018. The cement slab is poured in 2016. The body is already there under. That trespasser has nothing to do with this. The timeline doesn't work. Also, Rebecca was living at the house at the time frame this happened. She says, I moved in there in May. While I was there, Jeremy came over to visit. When? At lunchtime, when Laurie was on her break. Exactly the way Jeremy described when he would come. Not 3 to 4 overnight visits, which would obviously put his wife on notice that something was going on, which makes absolutely no sense. But Rebecca said that she had moved in, Jeremy would come over, during lunch, as Jeremy said that, but Rebecca was living there during this time frame. This didn't happen the way Laurie and Isabel said. In talking about the 2014 incident, Mr. Wiggs talks about how he went after Wilma Nicholas, and he pointed out that, well, the state prosecuted her or him, and you only got one side of the story. But that completely ignores the fact that Katina Vasquez, Laurie's friend, came in and said, you know what? Laurie told me she fabricated that. That's not the way it happened. She was the aggressor. She threw that flower vase and broke the slide glass door. She hit her husband over the head. And when Mike was saying that he was trying to basically grab her, to control her, to stop her from doing these things, that was true. That's her friend saying that. The timeline. Once again, go back to those phone records that establish that Mike Shaver's phone, the phone number that he originally had, changed 2 times, ultimately ending with a phone number that Laurie Shaver admits is hers, puts in a court filing is hers, showing you that she had that device the whole time. They want to insinuate maybe Jeremy Townsend said some of these messages from Facebook. Well, we know he's not sending the 500 pages to his wife to expose the affair. That's not him. Who had motive to do that? Her. We know he's not sending this message in September 20th, 2016, months after the relationship between him and Laurie is over and he's back with his wife, saying, hi Vanessa, how are you? Moving on looks good on you. Hope you and your son are doing well. After we know Michael Shaver is underneath the cement slab, we know Jeremy Townsend has no reason to send his wife that message. All of this connects back to Laurie. And all of it connects back to her in her attempts to cover up the crime that she committed, the murder. Mr. Wiggs, as he was going through, kind of picked and chose some things here about the heat of passion defense, and just kind of threw out some buzzwords like digital data he's been doing all week. But when he's picking and choosing through the excusable homicide heat of passion, you can't just pick some choice phrases out. You have to read it as a whole. And as you see, none of this, even under the May 2016 story that has no factual support whatsoever, would apply to this situation. The defense under the May 2016 version of events, which is completely refuted by the evidence, would be defense of others. That's it. Mr. Wiggs talks about how there's been no investigation into whether or not there was drag marks or chlorophyll testing. That's fake CSI TV stuff, folks. There's been no testimony whether or not that test even exists. Quite frankly, I've never even heard of that. He talks about Richard Connor and the long credentials of Mr. Connor and Corporal Strickland. He's just a corporal. He's just law enforcement. He doesn't even know what he's talking about. What did Corporal Strickland and Richard Connor say that conflicted each other? Nothing. Absolutely nothing. They both told you an IP address is something that is given to you by an internet service provider, and it's assigned a location. And it's basically like a physical address. That is what people will use in order to hook up their devices to the internet. They both said that. Richard Connor acknowledges that the Facebook records and the IP logs within them are the types of things that he, as an expert, relies on all the time. Richard Connor told you that those Facebook records that Mr. Wiggs wants to say are unreliable were reliable. He says that the fact that two different accounts are accessing the same IP address and close in time is consistent with them being in the same location. Knowing what that physical address is would be nice, but it is not at all necessary when you look at 2 years worth of IP addresses showing multiple times these two devices are accessing the same IP address. Where she was using both of these devices doesn't matter. The fact she was utilizing the same IP address shows that it's someone in the close proximity and the same person. That's what Richard Connor said, and that's what Corporal Strickland said. I've got a few more messages to demonstrate how this had nothing to do with Jeremy, and quite frankly, nothing to do with Michael Shaver, who's been dead since November. Mike Shaver has absolutely no reason for Vanessa and Jeremy to get a divorce. Laurie Shaver, posing as Michael Shaver, on April 18th says, "I'm sorry, Vanessa, you must be running scared. I heard J.J. Gall is a good divorce attorney." Who stands to benefit? She does. Mike Shaver, who's been dead now for about 5 months, stands nothing to gain from the divorce between Vanessa and Jeremy. Laurie does. We've already discussed the September 20th, after the slab has been poured. Makes no sense for Jeremy to have sent that message, but that is the "Hi Vanessa, how are you? Moving on, looks good on you." This last message, I ask you, is this a message sent by a man trying to inform another woman that his husband is cheating on him? Or is this the message of a woman trying to drive a wedge and get a divorce so she can get the man she wants? This is April 20th, 2016. "Hello, Vanessa. How are you doing? I know you asked for no more information." Right there. Vanessa said, I know there's this affair. You don't need to give me anything more. I got it. But I feel you should be aware of this. There are emails from October through November I have been reading. There is one from November 3rd where she asks him if he changed the sheets. He replied, no, that he had not. Loved being able to smell her and that he would inform you the spot was from him if you noticed. It appears she has been at the house and they have had sex in your bed. Thought you should know that. It also appears he invited her to stop by at your Halloween party, but she declined, not feeling comfortable with you being there. Pictures of that night were sent as well. There's a ton more information about how they met and what transpired. If you would like a copy of email logs, let me know. Vanessa tells him, I got it, I understand they're having this affair, you don't need to give me any more information. But Laurie says, you know I had sex with your husband in your bed, right? Who would do that? Mike Shaver? Jeremy Townsend? Chinese hacker? Laurie Shaver. Mr. Wiggs got up here and said, the state just wants you to be mad and check off guilty of second-degree murder because the state's proven to you that she had some affairs. And he said, specifically, why do we have to hear that evidence? We had to hear that evidence because these are the two individuals that he provided to law enforcement. When Laurie was first arrested, he said, you need to look into Jeremy Townsend and James Ballou. And how are they connected to Laurie Shaver in this case? They were having affairs with her. This all came to light because Mr. Wiggs told law enforcement, investigate these people. And they did. They did. Jeremy Townsend talked to law enforcement 3 separate times. Came in for his deposition. Came in, told you what was going on. And his testimony is consistent with the testimony of other people that he has no relationship with, that he has no connection to. Rebecca Urbanowski, who was friends with Laurie, states that Jeremy would come over during the day when she was on lunch break and wouldn't spend the night. That's what Jeremy said. Isabel and Laurie said he would spend the night 3 to 4 times a week. That's not consistent. Because it's not true. Oh, minor point, but this is just another example of how I think it's very important for you to rely on your own memory about testimony. Mr. Wiggs talked about Jessica Holcomb and how he says, she said this body was found in the middle of the fire pit. He was very insistent about that. He said, remember that video that was played. Please remember that video that was played. Because he confronted her on cross-examination. Didn't you say it was in the middle of the fire pit? No. Well, where was it then? And she sat there without missing a beat. That fire pit looks like, from top down, looks like the continent of Africa. And if you were to go into the bottom section of it and the point facing the house, and you were to go right under there, under where the depression was, that is where the body was found. That's what she said. Not what Mr. Wiggs said. The state has proven second-degree murder beyond all reasonable doubt because of all the evidence points that Michael Shaver, as Laurie said, is not a missing person. He's no longer walking the face of the earth. And he has been that way since before November 10th of 2015, when all indications of him and his life are gone. No bank activity, no phone activity, no contact with family, no contact with friends, no contact with work. Wasn't at the hangar where she said, wasn't in Georgia where she said. He's dead because she killed him. And then she made up this May 2016 story to distract. That's pure and simple what we have. If there is absolutely no evidence consistent with that May 2016 story, ask yourself why. And it's because she killed him in November. And because of that, she's guilty of second-degree murder with a firearm. I ask that you return the only verdict consistent with the law, the evidence, and justice, and that is guilty of second-degree murder with a firearm. She possessed that firearm. She discharged that firearm, and she caused great bodily harm or death. Thank you.
All right, thank you. Members of the jury, I thank you for your attention during this trial. Please pay attention to these additional instructions I'm about to give you. Rules for deliberation. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. Number 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. In this case, all of us are depending upon you to make a wise and legal decision in this matter. Number 2, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Number 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number 5, your duty is to determine if the defendant has been proven guilty or not. In accord with the law, it is the judge's job to determine a proper sentence if the defendant is found guilty. Number 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be reached as to each crime charged. The verdict must be in writing, and for convenience, the necessary verdict forms have been prepared for you. They are as follows. In the Circuit Court of the 5th Judicial Circuit of the State of Florida and in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01, verdict, count 1. We, the jury, find as follows as to count 1 of the charge. In parentheses, it indicates check only 1 as to this count. And there are A, B, and C. A, the defendant is guilty of second-degree murder. In parentheses, it states, if you checked A, please answer the following questions. Number 1, was the defendant in actual possession of a firearm? Yes or no. Number 2, did the defendant discharge a firearm? Yes or no. Number 3, did the discharge cause great bodily harm? Yes or no. In Section B, it states the defendant is guilty of manslaughter, a lesser included offense. In parentheses, if you checked B, please answer the following question. Number 1, during the commission of the manslaughter, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no. And C, the defendant is not guilty. So say we all, dated this blank day of September 2024, and there's a signature line for the foreperson. Verdict form, count 2. In the Circuit Court of the 5th Judicial Circuit of the State of Florida and in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01. We, the jury, find as follows as to count 2 of the charge. In parentheses, it states check only 1 as to this count. There are options A, B, and C. A states the defendant is guilty of accessory after the fact to second-degree murder. B states the defendant is guilty of accessory after the fact to manslaughter. In parentheses, if you check B, please answer the following question. Number 1, during the commission of the manslaughter, did the person who committed the manslaughter personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no. And for option C, that states the defendant is not guilty. So say we all, dated this blank day of September 2024, and again, there's a signature line for the foreperson. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over the deliberations. The foreperson should see to it that your discussions are carried out in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, or electronic communication such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Certain exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibit, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right, at this time, I will excuse the 2 alternate jurors. Ms. Davis and Ms. Hernandez-Urbina, you are the alternate jurors. You are excused from further service. Thank you for your time and attention. You may be seated. All right, then. Is there anything further before the jurors go back to deliberate?
No, sir.
All right, please bring the jurors back to deliberate. Thank you. Yes, ma'am. All right, the jurors have gone back to deliberate. Anyone have a clean copy of the jury instructions?
I can print one up.
If you would, thank you.
Yes, sir.
Seatbelt to test.
And, do the parties wish to review the evidence before it goes back?
No, that's fine.
Yeah, go ahead. I'm just finding the final jury instructions to send the task.
Yes, sir, thank you. You may be seated.
I emailed the final revised jury instructions and verdict form to the clerk, so when she's done,
Thank you.
Mr. Buxman.
Mr. Wiggs, if you could review the final copy before it goes back to the jury to make sure it's to your satisfaction.
It's the latest one, Mr. Buxman, then, I'm sure.
I'd like to leaf through it, so there's no...
Yeah.
It's a fresh one.
Ready now? All right, thank you, Madam Clerk. All of this. I think Madam Clerk just received the verdict forms. If you could send.
I'm sorry, you said.
Yes, two separate.
Thank you.
Yes, sir.
Eric, some requests that they're writing down. I told them to write it down and then I bring it right back. Also, just didn't want to go anywhere for this print. It's not questions, it's requests. No, not that. I know one is they wanted to use a whiteboard or something they can write on.
Any objections to that? State?
No, not all of it.
Okay.
And the other one there, that's all I'm writing down.
All right, you can send back a clean whiteboard without any additional writings on it.
No.
Well, I am little, but I can't see.
I can't take it back there with you.
I see what I'm doing there. It's locked, I'll get it. Yeah.
Thank you.
Well, there's a will, there's a way.
All right. Then send us back to you. Where would you like?
All right, Madam Clerk.
Thank you.
Which phone number would you like to leave with the clerk for contact?
Any other numbers?
352
Okay, will the parties please come up for the sidebar?
Yes, sir, they would like to come out and listen to the phone.
All right, are the parties ready for the jurors? All right, please bring out the jurors. All right, just one moment, please.
1 second just to make sure it's placed all.
All right, just one moment, please, Madam Bailiff.
Yes, sir.
that paperwork, or it's just at their, it's just at the property? Okay.
Okay?
All right, thank you so much.
Ready, Judge.
All right, please bring in the jurors. Thank you.
Watch the orange board, please. Another orange board is there.
All right, thank you. Please be seated. The audio tape has been queued up and ready for you to listen to. Like to listen to it one more time, or was that sufficient? Sufficient? Yes. Okay. All right, please bring the jurors out. Thank you. Jurors have exited the courtroom. You may be seated. Are there any other matters that need to be addressed before we adjourn?
Yes, sir.
Okay.
That's
You
it.
provided a phone number where you can be reached?
Yeah, I've given it to Mr. Capucci.
State, will you be in the courthouse, in your offices, or?
Yes, we're
They
going
have our phone number as well.
And we provided the clerk with our phone numbers.
All right. Thank you. If there's nothing further, then we'll adjourn.
Thank you, sir.
Thank you. Laurie Shaver. The jurors had a request and not a question. They requested a calendar for 2015 and 2016. Madam Clerk took the liberty of printing out a 2015 and 2016 calendar. If the parties could approach, view the calendars, and let the court know that it is to their satisfaction. And this is the request of the parties wish to view it.
Okay.
All right, I will file that with Madam Clerk.
Defense okay with it? Yes.
Okay, that stipulates, state stipulates, that the two calendars will go back to the jurors. Okay, there you go. Thank you. All right. I don't believe there's anything further, so we'll adjourn.
Thank you.
Thank you.